at the court at the jail?
Yes, Your Honor.
Great. First case is Roy Pepples.
Morning, Your Honor.
Mr. Pepples, good morning. Mr. Pepples, you're here for first appearance accused of one count of domestic battery. Mr. Pepples, there is probable cause in the charge, in the complaint. It's a case where the officer chose to elect to arrest both people, but I think there's enough there for probable cause. I know there's an issue with the bond, and there's a very new statute at play, or actually it's a rule of procedure at play. Mr. McDaniel, do you want to be heard on whether or not his bond can be revoked at this point?
Your Honor, I would just, I think the statute, or the rule change 3.134 is pretty clear. On the 63rd date, if the state hadn't requested an extension, I think his newest case is 70 days old today. So, I just argue that he should be on an ROR on that charge and that other charge. The question of retroactivity of it, I don't have the Supreme Court case with me, but there's a Supreme Court case that differentiates between procedure changes and law changes, substantive changes versus procedural changes. And generally speaking, procedure changes act on every case that's active. Substantive changes, apply prospectively. I would argue that, he should, those cases there, he's on an ROR at this point in time and not holding with that bond.
Is it your position it's an ROR without conditions?
Correct.
Is it your position then that the ROR automatically, the conditions automatically go away without any action by the defense?
Correct. I think this is limitations that the Supreme Court's put on the state, because essentially they asked for these changes in the Supreme Court rules, and it was primarily prosecutors that asked them. My, thought process is they basically put other kind of restrictions on there. Ironically, it's going to mostly affect people like Mr. Pebbles, who gets charged multiple times. But I think the Supreme Court is saying if a person is a bad person, then they should be filing something on them, not sitting on them. I think that was the Supreme Court's ideals, on that, to put some kind of restrictions on the state where they got to do something to make sure that the move cases are going to move forward if they're going to move forward.
So here's the question I have. The new rule 3.134B2, subsection 2, which is under the heading of defendants not in custody, says on the expiration of the time period prescribed in subsection 1, which is what you're talking about, and on motion with notice to the state, the court shall order that the defendant be released from all requirements of bail and all conditions of pretrial release unless the defendant has been formally charged with a crime. So that subsection seems to imply to me that even though there may be an ROR, there still can be conditions with it until there's a motion and notice to the state. So my question is he entitled to an ROR, but is this rule distinguishing that from all conditions of release and all conditions of bond? And the reason that's relevant in this case is the jail sheet is wrong in both cases. And in the case he's on bond for 25-270, he's on for a felony DUI. The jail sheet shows no special conditions, which I know that's very unusual. So I went back and watched the video, and Judge Patterson clearly put a condition of no alcohol. So the jail just didn't write it on the first appearance sheet, but the judge clearly said it. And then in case 25-222 CF, which is also on bond for, that's an ag assault, I put a condition of no contact with the alleged victim, which is the same person he allegedly was with yesterday. So the jail didn't write it on that sheet either. So Corporal, if you can make whoever's writing these notes for first appearance, if there's a condition of no contact or no alcohol or any other special condition, it needs to be on the first appearance sheet. So Mr. McDaniel, my question is, two different judges put conditions on bonds, and just because he's entitled to an ROR, does those conditions go away even though he's entitled to the ROR, Mr. McDaniel?
I'll read section B2, Your Honor, and it says, the court shall order that the defendant be released from all requirements of bail and all conditions of pretrial release unless the defendant has been formally charged with a crime. I think it's, when it says all conditions, I think that's,
you're not reading the 6 words before that. On motion with notice to the state. The defense hasn't filed a motion and hasn't been any notice to the state.
Correct. And that motion, the defendants do not have any kind of attorney at this point in time, and the Supreme Court has laid that out as the responsibility of the court to do. And I realize that it's going to be ugly if the court decides, well, we're just not going to do it. And then, who gets punished is, the defendants. I mean, this is, the court's supposed to do that on its own, and do these
The court
orders.
can't file a motion. I don't know that that's the court's responsibility.
So
On the
the statute-
expiration of the time period prescribed in subsection 1 and on motion with notice to the state, the court shall order. So you're saying you think it's the court's responsibility to do that, not the defendant or his counsel?
Correct. It is the court's responsibility.
Mr. Gill?
Judge, I have not reviewed this new change, but from my understanding, so he's on bond in two felony cases.
He was on bond in a felony case. More than 60 days later, there was a new arrest. The first one was felony DUI. No, the first one was ag assault.
Okay.
Then there was a new arrest for felony DUI that was outside of 60 days. At that time, Mr. McDaniel, Mr. Mitchell agreed that it became an ROR because the state didn't file charges. I think there were some questions about the ag assault. Now, another 60 days has passed since the second DUI, and the state still has not filed charges on either case. The first one or the second one, despite there being a breath alcohol level in the second DUI, second charge was the felony DUI. So Mr. McDaniel is saying that automatically, without any motion, without any filing by anybody, automatically he becomes an ROR, which this rule appears to say, but also that any conditions of the bond go away. And I don't know that I agree with that.
I mean, Judge, I haven't looked at it, but it says that upon filing a motion with the court and notice to the state, I would require that it had to be ruled on by the court by a motion from the defense before that goes away without seeing anything further.
Okay. Anything else, Mr. McDaniel?
Your Honor, I think the rule clearly says that the court files that motion. It's not the defendant. So,
Where does it say that at? Show me.
and I have to go back to the rule.
Yeah. I got the rule in front of me. I printed it out this morning. I'd love to see that.
So, it says rule part number 1, the court on the 60th day and with notice to the state must order the defendant automatically released on their own recognizance on the 63rd day unless the state files formal charges by that date. So, I mean, it clearly says. the court-
Where are you reading at? Are you in subsection
Section-
A or B?
I'm in B1, it says the last portion of that sentence, the court on the 60th day.
Okay, so let me just read for the record the rule. Defendant's not in custody. This is 3.134B. The state must file formal charges on defendants on pretrial release by information or indictment or in the case of alleged misdemeanors by whatever document constitutes a formal charge within 60 days from the date on which defendants are arrested or from the date of the service of CAPIS on them. If the defendant remains uncharged, the court on the 60th day and with notice to the state must, and under that must, there's an A and a B. A, order that defendant automatically be released on their own recognizance. First of all, that doesn't make sense to me because they're already out. So I'm not sure why the rule says they're to be automatically released when the heading of the section says not in custody, because so they're out, period. So anyway, you keep reading, must be released on their own recognizance on the 63rd day unless the state files formal charges by the state. So that happened because he wasn't in custody. He was already out. So he's released.
Well, I don't think the release is released from jail, Your Honor. I think they're saying release from pretrial conditions.
It doesn't say that. It says release on their own recognizance. Or B, if good cause is shown by the state, the court may continue the defendant on pretrial release for up to an additional 30 days unless the state files formal charges, which they haven't. And then there's a subsection 2, which says on the expiration of the time period prescribed in subsection 1, so on the expiration of the 63 days, and on motion and with notice to the state, the court shall order that the defendant be released from all requirements of bail and conditions of pretrial release and that unless the defendant has been formally charged with the crime. So clearly the state's got to have some notice from somebody. And I know that you're saying it's the court's responsibility to
It's
do
just
that,
like the
and
40 day. 40-day rule that we've done, forever, Your Honor. I mean, that's the court's responsibility to do that. And a lot of times, I mean, the PD's
That's not
office-
true at all. It's not accurate, Mr. McDaniel. The defense has to bring that motion forward. It's your job, frankly, to do that in the 40-day rule. Mr. Gill?
It's not.
And we
wrong?
also have, we can able to show a good cause for the reason for delay too. We have an option to, show a good cause.
Yeah, so I'm going to determine that you have violated conditions of your bond in both cases. It's your third arrest in less than 4 months. I'm going to revoke your bond in both 25-222 CF and 25-270 CF based upon the new offense, as well as having contact with the alleged victim, as well as consuming alcohol. So you have no bond in those two cases. You're entitled to a bond, Mr. Pepples, in a new battery charge. Your bond in that case is going to be $25,000 because you keep getting arrested. So you've got a $25,000 bond in one case, no bond in the other two cases, sir, and we'll be seeing you at an upcoming court date. I'm going to ask Mr. McDaniel to notify, actually, you can't notify your attorney because the state hasn't filed charges yet, so you don't have an attorney appointed. So, Mr. Gill, the state needs to make a decision on what you're going to do on these cases, and please talk with the other felony prosecutor about this rule,
Yes, Your Honor.
because y'all clearly have a 60-day requirement to do something. And,
Judge,
you know,
is there also a no contact provision with the cross complainant in that condition of bond on the new law?
yes, that condition is already there with the prior case, but we'll renew it in this case also. Thank you. So, Mr. Pepples, you don't have a bond in those two cases. I'm sure Mr. McDaniel is going to take appropriate action on your behalf, no court has interpreted this. This rule that I just read, this law, has been in effect 38 days. So it's a new statute, it's a new rule of procedure. But clearly there's some kind of motion to be filed by someone and the state has to be given notice. And I'm not going to find that specifically written rule is meaningless. It means something. And we need some guidance from some appellate court or some Supreme Court. But for today, I'm determining that there's no notice been given. And so you were clearly entitled to be released from jail, but you weren't in jail, but you were entitled to be released. So I think a reasonable conclusion may be that the bond goes away, it becomes an ROR, but the conditions of the bond, such as no contact with alleged victim, only go away upon a motion and a hearing and giving the state a chance to be heard. That's how I'm reading it anyway. Mr. McDaniel, anything else for the record, sir?
Judge, I'm just going to respectfully object and, with the things up on the record, and I do realize that motion is supposed to be filed, and I'll send you the stuff again. I'll send you the rule. I think it clearly says the court is responsible for that.
I just read the rule and I'll give you another chance. If you ever see that in that rule, please let me point it out to me. It never says it's the court. It says on motion with notice to the state. So
It says
I think that-
the court on the 60th day and with notice to the state must. I mean, I don't know what else. I mean, it says must.
it doesn't say that. You're adding words to this rule. It never says the court.
B1, the last portion of B1.
If the defendant remains uncharged, the court on the 60th day and with notice to the state must. Oh, I see what you're saying. You're saying that section 2 is a continuation of that same paragraph.
Correct.
If the defendant remains uncharged, the court on the 60th day and with notice to the state must A or B. So A was
Correct.
done. And then there's a subsection 2, which is not part of subsection 1. Subsection 2 is a totally different subsection.
Judge, you're confusing part A being released from jail and part B when they're out of custody. I mean, so there is a section part A that's about when they're in custody and being released. Section B is about release from pretrial conditions.
So when there's a statute that says subsection 1, A and B, and then there's subsection 2, subsection 1 doesn't control subsection 2. It's a totally different rule. Subsection 2 is an independent subsection of Florida Rule of Criminal Procedure 3.134. So what you're trying to do is say, because in part 1, it said the court's got some responsibility, that also applies to part 2. Part 2 doesn't say that. So that's my ruling today. We'll let the appellate court give us some guidance on this,
Thank you, Your Honor.
perhaps possibly ambiguously written rule that we're trying to follow and discern and interpret. So you've got no bond for the time being. We'll see what happens from there. Any questions, Mr. Peoples?
No, Your Honor.
Your Honor, just to
Have a good
clarify,
day.
my interpretation is section B is all dealing with that same part, and it's all, that's.
It's not
Part
section
one.
B. Section B does. Subsection 2 is different. Subsection 2 says nothing about the court has an obligation to do anything. It's not my job to make a motion.
It says on the
In regard-
expiration of time period prescribed in section 1, which is the court's duty there. I mean,
Yeah. So, Mr. Gill, my concern is this. My concern is you've got a case with no contact with the alleged victim. And the state sits on the case like they've done in these two cases and doesn't make a charging decision. I know you're shorthanded. I understand all that. But some cases have to go to the top of the line. And you've got a condition, no contact alleged victim. And that 60th day, if Mr. McDaniel's right, because y'all haven't filed charges, if he's right, automatically those no contact conditions goes away. I don't think that's the intent of the rule or the intent of the Supreme Court to take the no contact away. I think the intent is to deal with him being in custody or having bond in place. So somebody in the state attorney's office has got to be on top of these cases. And this is now 3 arrests this young man has had in 90 days, 120 days, something like that. All right, so next case is probably more confusing. Kendra Williams. Corporal, I need some help on Miss Williams or Miss Pittman, I'm not sure.
Kendra Pittman, Ms. Pittman.
Okay, so Miss Pittman, good morning, Miss Pittman. This is not your fault at all, ma'am. The complaint says Kendra Pittman. The jail sheet says Kendra Williams. Is your name or has your name ever been Kendra Williams, ma'am?
No, sir.
Okay, so Corporal, we have any idea where Kendra Williams comes from on the jail sheet?
I'm not sure why Lickford
Terry
typed
Williams,
that up,
the
Your
next
Honor.
name.
I did realize the birthday was a mistake when they fingerprinted her. They put in the wrong date. That's why I had to use that year to pull her criminal history. Somebody made a mistake when they booked her in.
Okay, so it's the wrong name and wrong date of birth, Miss
Yes,
Pittman.
sir.
So Miss Pittman, I think the criminal history the jail sent me is correct. According to it, you have no criminal history. Is that accurate, ma'am?
Correct. I've never been arrested.
Ms. Pittman, you're accused of 1 count of domestic battery. There is probable cause for it, but your criminal history is perfect. Let me see if Mr. McDaniel has anything on your behalf before I hear from Mr. Gill. Mr. McDaniel?
Your Honor, she lives here locally. I mean, we just asked to give her maybe an ROR or conditional release and just let her come back to the court date on the 25th, 9 o'clock. It's a pretty weak case. And,
I didn't go back. I think in the other one, she said he struck her. Did he ever say that she struck him? Or was it just based on,
I believe he says it was not physical, just breaking things. I think
and I'm not sure there is probable cause in her case, Mr. Gill.
Judge, the state would submit that there is probable cause based on the injuries to both individuals and that Roy, his statements were not accurate as to the injuries, showing that there was physical violence between both of them, where a primary aggressor cannot be established by the officer.
Mr. McDaniel?
Your Honor, I mean, I, at the very least, it's a very weak case. I think we all recognize that this case is not going to go forward. So, I mean, I don't see, if there is probable cause, it is very, very weak, but it's up to the court.
Thank you. Ms. Pittman, I'm going to find no probable cause. Being in a fight and having injuries is not probable cause for battery. If someone says you caused those injuries and they describe the elements of battery, that's probable cause. The officer doesn't have the elements of battery in this complaint. There's no probable cause. I have no idea what happened. I just know that he couldn't determine it then, and I certainly can't determine it, the next day. So you're going to be released this morning, ma'am. There is a condition of no contact between he and you in his case. You need to understand that. There's a condition of no contact. So if at some point he posts bond, I've clearly put a condition of no contact on the record, Ms. Pittman. If he contacts you, you don't need to contact him at all. If he contacts you, you need to contact law enforcement. You can be released this morning. You have any questions?
No, sir. Thank you.
Yes, ma'am. Have a good day. Terry Williams. Mr. Williams, good morning. Mr. Williams, you're here for first appearance accused of 1 count of tampering with a witness, victim, or informant. I saw Ms. Jernigan come in. Mr. Williams, there is probable cause for this charge, sir. I'm going to listen to the attorneys before I decide your bond and any conditions of bond. Mr. McDaniel, Mr. Gill, I'm also considering revocation of his telephonic rights other than with his counsel. So I'd love to hear your position on that. Mr. McDaniel?
Your Honor, I don't think there's no need to take away of any, was the alleged telephone calls from the jail or was?
Yes, sir.
They were, okay, I apologize.
Yes,
And,
sir.
yeah, so I don't have anything, Your Honor.
All right, Mr. Gill.
Judge, this is a secondary felony. It's punishable up to 15 years in the Department of Corrections. The state is asking for his telephonic rights to be revoked as well as his bond to be revoked in 24 CF 512. And then just a reasonable bond in the new law case, Your Honor.
Thank you both. Mr. Williams, I'm going to set your bond in the new case, a tampering charge of $25,000 bond. I'm going to revoke your bond. In the previous case, you did have a condition of bond, have no contact with the alleged victim. There's evidence that you violated that repeatedly. I'm going to instruct the jail to remove all your phone privileges with the exception of telephonic contact with your attorney. No phone privileges because it appears you've abused that. So they'll stop all phone contact, period, other than your attorney. And we'll see where it goes from here. But you have no bond in the old case. So there's no point trying to postpone in the new case, Mr. Williams, because you wouldn't be released. Mr. Williams, do you have any questions?
Yes, sir. This is my wife, and the judge didn't never tell me I couldn't talk to her.
Trying to remember if
When
I
I
watched the video this morning, and in this case, I don't think I wasn't the judge, but did I watch the video or did I just read the file? In this case, I believe it's on your paperwork from the jail. I think in this case, the jail actually wrote it down, but let me go look at that and see. I don't know that I had time to watch the video on yours, but I certainly can.
Yeah, he ain't never tell me I couldn't talk to her.
Mr. Williams, don't say anything else. I want to try to answer your question, but I don't want you to say anything that's going to hurt you. But I feel confident the judge did do that because that's a rule in Florida that you must impose a condition of no contact with an alleged victim unless the victim is there and the judge can make certain findings that the victim's wanting to have contact and so forth. Let's see, what was the case number? I think it's 24-512 CF.
Yes.
It's a good thing technology has come a long way, Mr. Williams, so I actually have the ability to watch that first appearance now.
Judge, I'm looking at a copy of the first appearance paperwork on September 21st of 2024. Judge Young's paperwork signed, no contact with victim as a condition on the paperwork.
Mr. Williams, the paperwork says no contact. Would you like for me to watch the video from your
Yes, sir,
first appearance? Okay. I'll
Yes,
watch the
cause he
video.
didn't tell.
We'll watch the video. It won't take just a minute and I feel confident that he did. I cannot imagine the jail writing it down on the sheet. Them not writing something that should have been written is one thing. That happens all the time, unfortunately, but writing something down that shouldn't have been written is a different type of error and much, much rarer. So here we go right here. Got to turn my volume on.
Felony possession of method. Four charges against you. I'm not Where's that?
Shit.
City. Where's that? Where's that? Are you employed anywhere?
All right, so that's not gonna work. Let me try to get to the part where they. All right, so that's not gonna work. The problem is I'm getting feedback because I got my speaker on my computer on. It worked for a while. All right, so there is a condition of no contact and revoking your bond. There's evidence you violated that condition of no contact multiple times. Any other questions, Mr. Williams?
I just want to know, can I get a bond for it? That's all I want to
No,
know.
you cannot get a bond. It appears you violated what a previous judge told you not to do. So no, you're not getting any other bond. I'm revoking that bond. Do you have any other questions, sir?
Sir,
Have a
that's
good
my
day.
wife, so I don't know.
No contact, even if it is your wife, you're accused of a crime on her, Mr. Williams, and the judge ordered you to stay away from her. And now you're accused of contacting her from the jail and encouraging her to drop the charges. That's why you've got no bond. I wish you the best, sir. Next
I'll get the
case.
court in order, Judge.
I'm sorry.
I'll get the court in order. on
Thank you. Thank you, Mr. Gill. Serena Shipes is next. Ms. Shipes, good morning. Ms. Shipes, you're here, ma'am, because you've been accused of one count of driving while license suspended or revoked with knowledge. Ms. Shipes, I've read the complaint. In your case, there is probable cause. I took a look at your criminal history, and it appears, ma'am, that you've been to prison 3 times. Is that accurate, Ms. Shipes?
Yes.
It also appears you have, I think I counted 6 prior driving license suspended, but the most recent one was 6 or 8 years ago. So it has been a while since you've had one. I am aware of that. Let me see if the attorneys have any additional information, Ms. Shipes, before I set you a bond. Mr. McDaniel, anything?
No, just taking into consideration, this is a financial issue only that's dealing with criminal cases that she has in Washington County. She did have a deal worked out with them, but she was unable to fulfill the payments that the clerk's office wanted her to make on all the felony cases that were out there that she's had over the years that you described. So she's trying to do the best she can, I guess, to get her license.
Thank you, Mr. McDaniel. I did not catch that. It was a financial related suspension. So thank you for pointing that out. Mr. Gill, anything from the state?
Nothing from the state, Your Honor.
Ms. Shipes, I'm going to set your bond at $5,000 cash or surety because of the history primarily, ma'am. You have a condition not to drive a motor vehicle unless you get a valid license. Ms. Shipes, if you get a license, you can drive, but you cannot drive until you get a valid license. It's a cash or surety bond, so you can go through a bondsman. Ms. Shipes, do you have any questions, ma'am?
No.
Have a good day, ma'am. Next, we have Aaron Summerlin. Now we've got Mr. Green and Ms. Jernigan here. We'll take that case next. Mr. Summerlin, good morning. Mr. Summerlin, Mr. McDaniel's added you on the docket. He's trying to get your case resolved. So listen to your attorney and we'll see where we go from there, sir.
Your Honor, I spoke to Mr. Summerlin in case number 25370 He's going to plead no contest to the charges listed. The understanding he'll be sentenced to 6 months in the county jail. He'll have 29 days jail credit, $722 fine. He'll be guilty. He has signed his plea waiver form, waiving his right to jury trial and call witnesses.
Thank you. Mr. Gill, is that agreeable with the state?
It is, Your Honor.
And Mr. Summerlin, did you hear that agreement, sir?
Yes, sir.
And Mr. Summerlin, any questions about that agreement?
No, sir.
Is that the plea that you would like to enter?
Yes, sir.
Mr. Summerlin, I'm going to accept your plea of no contest. In case number 25-370 to the charge of battery, sir, I'm going to judge you guilty of that offense. Sentence you to 6 months in jail, but Mr. Summerlin, you have credit for 29 days you've already served. I'm also going to impose a standard court costs and fines set by state and county law at $722. Mr. Summerlin, there's no probation involved in this sentence, sir. What that means is when you finish this jail sentence, you're released, no further probation or anything. Mr. Summerlin, I do wish you the best. Do you have any questions?
No, sir.
All right, sir. Have a good day.
Sure will.
Let me do Mr. Ivy last because it may take a little more time, Mr. McDaniel. So let me finish your cases and we'll do Mr. Green's case. Sean Bass is next. Mr. Green only has two other pleas. Shouldn't take just a couple of minutes. This is State versus Sean Bass. Mr. Bass, good morning. Mr. Bass, Mr. McDaniel's added you on the docket today trying to get your case resolved. So listen to Mr. McDaniel, please.
Your Honor, I spoke to Mr. Bass in 25195 MM. He's going to plea of no contest to the charges listed. You understanding he'll be sentenced to 30 days in the county jail. He'll have 22 days jail credit. There'll be a $370 fine. He'll be adjudicated guilty. He has signed his plea waiver form, waiving his right to a jury trial and all
Madam Clerk's question, is he pleading on both counts?
Correct. Just both of them run concurrent.
And Mr. Gills had agreed with the state.
It is, Your Honor.
Mr. Bass, did you hear that agreement?
Yes.
Mr. Bass, is that the plea you would like to enter to resolve these cases, sir?
Yes.
Mr. Bass, I'm going to accept your plea of no contest in case 25-195 MM to the charges of affray and trespass, structure, conveyance, and judge you guilty of those offenses, sentencing you to 30 days in jail on each case concurrent. But Mr. Bass, you have 22 days credit on each charge, so you have a total of 8 days left. You may do a little less than that. You may not. That's between you and the jail. But I'm also ordering the court costs and fines of $370 only on count one. That will become a civil judgment against you. Mr. Bass, Mr. McDaniel, I feel like has probably told you this. Be aware under the recent procedural changes with our clerk's office, your license will be suspended if you don't pay that fine after a certain period. I think it's 90 days perhaps. So be aware of that, even though you may not have enough time left to get the fine worked off is what I'm saying at the jail. So if you don't get it worked off, you've got to pay that fine or they're going to suspend your license, or you've got to enter into a payment plan with them. They're pretty reasonable, very reasonable about the payment plans if you choose that option. Mr. Bass, no probation involved in this sentence. Any questions, sir?
No, sir.
Wish you the best, Mr. Bass.
Yes, sir.
Mr. Dixon, good morning. Mr. Dixon, you're here for a bring back. Mr. McDaniel's trying to see if we can get your case resolved. Mr. Dixon, please listen to your attorney, Mr. McDaniel.
Your Honor, I spoke to Mr. Dixon in 25379 MM. He's going to plead of no contest to the charges listed. You understand he'll be sentenced to 9 months in the county jail, 24 days jail credit, $370 fine. He'll be adjudicated guilty. And if he does, find some kind of rehab that he can go to, then I don't think the state has any objection to him going to it. But at the last time we couldn't. I don't expect anything's going to change. So, so we're going to go ahead and resolve. He has signed his plea waiver form, waiving his right to a jury trial and call witnesses.
Thank you, Mr. McDaniel. Mr. Gills had agreed with the state.
Yes, Judge, no objection to a rehab facility if he qualifies.
So, Mr. Dixon, I'm not going to promise you that I'll let you go to rehab. I would love for you to go if it's the right fit and if it's long enough. I certainly will consider it. The state's not opposing it, but Mr. McDaniel's telling me they hadn't found one in the past. So, Mr. Dixon, you very well may end up doing the sentence. If they find a rehab, you'll come back to court and we'll talk about where it's at, how long it is, and so forth. Mr. Dixon, knowing all of that, do you have any questions?
Can I ask one question? Why
Sure.
did the police come run me there and drop me off? I hadn't did nothing.
I don't understand your question.
I'm trying to figure out why I'm in jail.
Judge, I'm not sure if he actually wants to plead right now. I've had multiple conversations with him. Just to remind you that the stuff with the drug rehab is because he can't read and write. That's the issues with that. And
I remember now.
There's some learning disabilities here, I think, and I'll call with him some more. All right.
Okay.
Good luck to you.
So, Mr. Dixon, we'll see you at a later court date, sir. So that brings us, I think that's it for your cases, Mr. McDaniel. Anything else you have, Mr. McDaniel?
Nothing else, John.
All right, so we have one of Mr. Green's cases. Mr. Green is here in the courtroom. He's been waiting patiently. This is State versus Shawnest Ivy. Mr. Ivy is here on the violation of state probation. We do have our probation office here now. Ms. Jernigan, I apologize you weren't given advance notice. Ma'am, we're going to try to fix that on these pleas in the future. But Mr. Ivy, listen to Mr. Green, your attorney. I think there's a framework for a plea agreement here, possible plea agreement. And I don't have the case number, Mr. Green, in front of me. So if you
It's
could put that on the record.
24-610, Your Honor.
Thank you. And Mr. Green, where do we stand?
Your Honor, I've talked to Mr. Ivy again last night, or late yesterday afternoon. And he's entered, the state has offered for him to go to modify to get him 6 months of drug offender probation for the curfew. I've talked to him and he signed the paper to enter that plea. But what he'd really like to do is to go to a drug rehab center. We don't have one. He hasn't been screened for one yet. But what I'd ask the court to consider is letting him plead to this and get on the drug offender probation and let them go ahead and the probation officer, just talk to probation officer, Ms. Jernigan, and see if they can go ahead and get him from drug offender probation to into an inpatient drug treatment and bring him back once that is if they can find him a place.
So is the inpatient drug treatment part of the plea, or is it something, because last time he was going to do it voluntarily and then he got
Well,
arrested before he could?
He'll do it voluntarily, but it's not part of the plea, but he would voluntarily do it. And I think it could, the probation office could help him get a placement. And then we could modify his probation for the drug offender probation to a inpatient drug treatment.
Okay, so I understand your position. Mr. Gale, tell me what the state's position is.
Judge, yes, I believe that the ultimate goal was to get Shaughnessy Ivy into an inpatient drug treatment facility. I've been in contact with Ms. Colbreth. She's been working on that. I don't believe she has said that he has been admitted into a facility. I think she's working on a bunch of that. In the meantime, I had proposed, well, if that doesn't, come to fruition, I would be willing to do 6 months DOP. And that was the offer I tendered. I think that based on some conversations, the only concern with DOP is that there's a transportation issue that Mr. Ivy, and I don't want to set him up to fail, that he can't get to some of these things that DOP requires him to do. That's where we are, Judge. I'm happy to, I really don't know what to do at this point, other than that's the state's offer, inpatient drug treatment or 6 months DOP. And it's up to him and what his advice of his attorney.
Thank you both. Mr. Ivy, where do you live at?
I live on Highway 2 out there, Troy County. My thing is, John, is this here. I can do once a month, check into the probation officer, but I don't have a job and I don't have a license, so I don't want to get caught driving with no license, trying to make it till every week up there, because I got to check in every week. So my thing is I can show up once a month, but the weekly thing I can't do.
So on drug offender probation, there's a condition for a certain number of weeks that you must come in once a week to be drug tested. Is that right, Ms. Jernigan?
Right.
I want to make sure he can hear you. So that mic, I don't know if that microphone's live or not.
No, sir, it's changed.
Okay.
On drug offender probation, they'll report into the office on a monthly basis, but they have a curfew. The weekly meetings would come into play when he has to go to drug treatment. And that's weekly group meetings. And then another meeting, that's an individual meeting. So 5 times a month, he would have to go to treatment meetings.
Are any of those located near the Campbellton area?
No, they occur in Mariana.
Okay. Mr. Gill, that's the state's offer, is that right?
Yes, Judge. I will make another offer today. I don't know if the court would accept it. I believe that we're rescheduled, if we don't have anything resolved today, that we're rescheduled for an evidentiary hearing on the 20th. The state would offer today 120 days jail. This is a low-risk technical violation, Judge. Given that he has over 90 days, he's now at, I believe, 100 days. The state would offer 120 days with, he has credit for 100, so that's 20 more days left. And then that the only other condition that is modified is that he has a curfew. I'm willing to.
I wouldn't accept that.
Okay.
When he pled originally, same prosecutor, same defense attorney, well, maybe Mr. Green wasn't original.
I don't think
He
so.
said he needed help.
Right.
And I went ahead and let him enter the plea and he was going to get help and he didn't make it a week before he was arrested. It was 7 days, I believe. So no, I'm not going to accept a resolution that doesn't give him the help that I believe he needs and he himself said he needed. So I wouldn't do that.
Okay.
I have no problem with the drug offender probation. You need to understand there is a point I'm being told you will have to report weekly And if you can't do that, you don't need to take it. I was gonna have a problem going forward to the VOP hearing. Lastly, if you take the drug offender probation and you violate, then I'm not gonna be sending you to drug treatment. Let me back up. If you violate in a willful and material way, in other words, if you test positive, if you don't report in, if you disappear, if you commit a new crime, if there's allegations against you like that, then I'm not gonna send you to drug treatment then. I'm gonna send you somewhere else. So Mr. Ivy, you need to understand, I want you to make it. I'll be your biggest fan, but if you can't do this, don't commit to it. So do you want to take the drug offender probation or do you want to just go to the VOP hearing?
Shoot, the ball in your hand. You, if it's left up to you, like to me, if I go to VOP hearing, I know I can win the VOP hearing, but when it's all said and done, it's up to you. You see what I'm saying?
I don't know if they can prove you violated your probation or not. I know the allegations with a new charge, it was a misdemeanor. And in that new case, the state has shown the misdemeanor prosecutor has shown some desire to dismiss that case if you enter a plea. In this case, the second violation was allegations regarding a positive urinalysis at the jail. That's all I know. And whether they can prove it or not, I don't know. But that's the allegations against you as I understand them. So you've got to decide whether you want to go to the VOP hearing or whether you want to take the drug offender probation and get a shot at drug offender probation. And if you complete it, great, everybody's happy. But you need to make it a whole lot more than 7 days before a violation like last time. An alleged violation, at least.
What about this? Stephanie said she was gonna get me a halfway house. I talked to her over the phone. She said she was gonna get me a halfway house.
She's had a month to do that. It's been 3 weeks, Mr. Ivy. I have no idea why it's taking so long to get you somewhere. I don't know. I'd love you to go. I'd sign for that today, but they haven't found you a place apparently.
Y'all, there's a difference between the halfway house and the rehab. She said the halfway house, she can get me there in the next day or two. I talked to her over the phone.
What do you mean by halfway house?
A halfway house is like I don't have no lights on at my house. So in other words, what she's saying is she can get me there as live so I can live there and go to all my meetings and whatever I have to go to.
Do they have a drug treatment portion or a part of that?
That's what she said. I talked to her over the phone. So I just take the drug from the program, whatever. I'm just trying to make it. So.
Mr. Green, are you satisfied?
If he wants to try, you're gonna have to come in once a week to do things, and if you don't do them, they're gonna violate you.
Let me ask you a question about that. You said when the counseling portion starts, when does that begin? Immediately, or is there a certain time period when that?
No, we have 30 days to make the referral. The evaluations occur every Tuesday morning at CARE. So if he was released today, he could possibly get into an evaluation on Tuesday. And then based on that evaluation, the weekly groups would start the following week.
And the weekly groups are in Mariana?
Yes, at CARE.
So at some point within the next 30 days, you would go to the evaluation. And then after the evaluation, there's a good chance you would then go to weekly meetings. If Ms. Colbert finds you something in the meantime, that it's an inpatient program that you want to go to, then we'll get you back and send you to that. I don't have a problem with that. But I don't have no faith they're going to do that because they've had a month to do it and they hadn't found your program yet. So there's some issue. I know that you were accused of leaving a program in the past, and I don't know if that's the issue or if it's something else. I have no idea. Today's the first time I've heard they couldn't find a program. So Mr. Ivy, do you want to take this off, or do you want to wait and see, hope for something different comes through?
Sir, I got to give it a shot. I got to get out there. I'm doing dead time here, I'm doing dead time. I got to give it a shot. It's time to change. I didn't do nothing wrong from the get-go, but I got to give it a shot. I got to get out there, sir.
Okay, so you do want to take the drug offender probation. Is that what you're saying?
Yes, sir. I just don't want to have no issues with Miss Journey because we had issues in the past. I don't want her to just violate me, just because, but I take it. I take it.
I won't be the officer.
Ms. Jernigan says she won't be the officer.
Okay, thank you. Yes, sir.
That seals the deal right there. Okay.
Okay.
So Mr. Green, I'm gonna ask Mr. Green to put the agreement on the record. Let's make sure that we're all on the same page and this is what you want to do. Mr. Green.
Your Honor, on behalf of Sean S. Ivy, in case number 24610, and move to withdraw his form of plea of not guilty and a plea of no contest to violating probation agreement with the state subject to the court's approval. So the court would modify his probation and adjudicate him guilty if he hasn't already been. Sentencing to 100 days in the county jail, give him credit for 100 days in the county jail. All prior conditions would be reimposed. The $500 monetary obligation added to his probation. He'd be placed on 6 months drug offender probation with a curfew. It's a low risk technical. And I think that's it, Your Honor.
One other condition I
Thank you,
think
Mr. Green.
we had discussed, and that was dismissing 25215 the trespassing case.
Yes, right. At this time, the state would move to dismiss that case, and I'll file a written dismissal of that as well. I have a score sheet here.
And that plea agreement is acceptable, Mr. Gill. Thank
One
you.
more
And
question.
Mr. Ivy, yes, sir.
One more question. If I decide to take this year and a day, right, I come back in front of you, I got 308 days credit. Will you accept that?
I don't
With
know
the
how
year
much your
date?
total credit is, Mr. Ivy, but it's all calculated. It's all there. I mean, we can go back and calculate. You have 100 days since your last arrest.
Do you show it? Do you happen to have his credit there, Corporal?
You got it.
We have, a split credit, one is 108 and one is 205.
Most years.
So I can go and resolve it. I can get this over.
316.
313. So his other offer was 366 in prison with 313 credit.
My offer was
Why in the
a
world
year
would you
and a day.
take house arrest or drop off if you?
That's what I'm trying to say. That's why I can go and resolve this right now. I can get this over with right now. I
Mr.
ain't
Gill,
gonna-
that was
I
the
ain't-
offer, wasn't it?
I've offered,
Yeah.
Mr. Ivy, also a straight, it was I believe, I don't remember what it was, but I offered him a DOC offer
It
to
was a
resolve
year
this.
and a day, wasn't it, Mr. Green?
I believe it was a
I
year.
got it.
I don't know exactly, Judge.
So Mr. Ivy, let's make sure the other offer that was made to you at your last court date was 366 days in prison, which is a year and a day with credit for the time you've served. You now have more credit than you did back then, so you have a total of 313 days credit. So
Well,
are you saying you'd rather do that?
I'm saying that's, I just go down there. Yes, sir.
Okay.
I want to do today.
Mr. Green?
That'd be his best deal. He'd be off probation in a couple of weeks. He go in there and get his teeth cleaned and come home and he's through.
I think Mr. McDaniels explained to him the transport process because he said something about leaving today. Mr. McDaniels explained to him, I believe. That doesn't happen daily. The transports are weekly or bi-weekly.
But he wouldn't be there very long. And he'd be through with it. That'd be his best deal. Then he'd start all over again.
So, Mr. Ivy, let me wait till Mr.
I'll
Ivy.
take it.
You would rather do the year and a day in Department of Corrections, convert all financial obligations to a civil judgment, give you credit for the amount of time you served, which the jail is telling me is 313 days, and no probation, no house arrest, no DOP, nothing left. Is that what you want to do?
Yes, sir. And could you please put it on writing in that paperwork, sir? So when you get down there, they can see all this credit. Please, sir.
I will mark all his credit on there.
I'm going to ask you to go ahead and do that now.
Thank you, sir.
Well, he would have to sign it.
Oh, he
So
would.
let's go ahead and take this one that he signed and make changes. I'm going to
Okay.
read him to those changes
Sure.
and make sure that's what you want to do. That way you don't have to get it to the jail for him to sign another one.
I can get him.
So
out here
while they're
signed.
getting that signed, I'm going to read it to you when they get it done. Mr. Ivy, let me get you to raise your right hand, please. Mr. Ivy, do you solemnly swear or from the testimony about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Ivy, you accuse of violating your probation in case number 24-610CF. In that case, you can put your hand down, Mr. Ivy. You have the right to a violation of probation hearing. Mr. Ivy, if you go to that hearing, the attorney will represent you at that hearing. The state will try to prove that you violated the terms of your probation. And that attorney, Mr. Green, would argue on your behalf. And if they don't prove it, you'll be reinstated on the supervision you were on previously. However, you have the right to waive that hearing. And if you waive that hearing, there will not be a hearing. You don't get to call witnesses. You don't get to cross-examine the state's witnesses. And in exchange for that, a specific sentence is entered. Do you understand all of that?
Yes, sir.
And do you want to waive the right to that hearing with the understanding that you'll be sentenced to 1 year plus 1 day in the Florida Department of Corrections and given appropriate credit I've already put on the record today? Is that what you want to do, Mr. Ivy?
Yes, sir. Which is 308 days credit, right, sir?
313.
313.
Would you
yes,
rather
sir.
have 308 or 313?
313. Yes, sir.
Mr. Ivy, do you feel like this is in your best interest?
Yes, sir. I'm
All right,
ready.
so you've already signed a waiver of rights form, but that waiver of rights form, which you've already signed, had a different agreement on it. It referenced the drug offender probation. So Mr. Gill has modified that form, and I'm going to read to you the changes. So just so we're all on the same page, because you want the specific credit on the form, and I would too if I was in your shoes. So we're going to make sure it's there, okay?
Sure.
Help me remember. Was it 308 or 313?
313.
Okay, so let me see that form.
Okay,
Mr. Green, are you satisfied these changes reflect the current agreement?
exactly, Your Honor. And Your Honor, I went yesterday and he signed that in my presence, and you understand what we're doing. You just marked out what you had signed yesterday and put on what you agreed to today. You understand that?
Mr. Ivy, you understand that?
Mr. Ivy, you understand that we just marked out on the form you signed yesterday what the agreement was, and we put the correct, what you've agreed to right now, to a year and a day with 313 credit.
Okay. So the changes on the form are the DOC now says 1 year, 1 day. The day's credit says 313. A civil judgment on any financial obligations, and your probation is revoked. Mr. Ivy, I'm going to accept that plea, that admission that you violated your probation, revoke your probation, sentence you to 1 year and 1 day, which is 366 days in the Florida Department of Corrections. I'm going to give you credit for 313 days you've already served. Any financial obligations will become a civil judgment. Mr. Ivy, I'm going to find this is a guideline sentence, Mr. Gill? Or was it not?
I believe it's barely under a guideline sentence, Your Honor. This course you should reflect, I think, is it 14?
I got one more thing, Your Honor.
So hang on just a second. I'll be glad to answer that. So it's either it's 41 total, 47 total points.
It should be guidelines.
So it's a guideline sentence.
It's also low risk technique.
So Mr. Ivy, there's no probation involved in this sentence. Mr. Ivy,
Yes, sir.
it's my belief you still need some inpatient drug treatment based upon your prior statements. So I would encourage you, when you get out, if you want us to help trying to find your program, contact Ms. Colbert or contact Mr. Goodson with the probation office, and they can try to find you a program. You need to do that before you get in trouble. Mr. Ivy, I don't want you to get out and get a new charge and then say, I need treatment. If you need help, as soon as you get out and get this behind you, let's get you some help. You'll be going voluntarily. That would be a good benefit if that's something that you think would benefit you like you felt at one time. Now, do you have any questions, Mr. Ivy?
Yes, sir. I got one more resolution. You said on that paper that I signed, when that was the day that you were gonna give me additional 45 days if I signed it. I got it on black and white, Your Honor.
What?
Yeah, that was, I think at that time, the credit, there was some conversation about artificially increasing his time on a different sentence. It may have been 18 months in the Department of Corrections. They were going to try to increase it to try to get it down where it was less than the amount of time he would do in the county jail.
I can try to pull up the email, Judge. I think I had it in the email.
Mr. Ivy, there's been so many conversations back and forth. The attorneys did approach me about that. But Mr. Ivy, this is your sentence. That's the sentence I've imposed, and I do wish you the best. Mr. Ivy, any questions?
No, sir.
And lastly, your other case, your 25-215 is being dismissed pursuant to this plea agreement. So that misdemeanor trespass is dismissed, Mr. Ivy.
Yes, sir. Thank you, sir.
Yes, sir. I wish you the best. Okay, let me look at something on that case because he refreshed my memory. And he did not have that much credit. Not even close to that much credit last month. At least what's related to me wasn't close to that. Is it 610? The one we just did, was it 610 CF?
Correct.
Judge, I need to correct the score sheet as well. I apologize.
Yeah, it does look right. All right, Mr. Green, that's everything I had. Anything else, Mr. Green?
No, Your Honor, except I'm gonna put on my calendar, I'll probably see Mr. Ivy in 53 days.
Hopefully not.
Hopefully not.
Thank you, Mr. Green.
All right, thank you.
Mr. McDaniel, we're going back to Ms. Shipes.
Yes, Your Honor. I spoke with Ms. Shipes, and I think at this point in time, she's just going to enter a plea of no contest to the charges listed. Understanding she'll be sentenced to 60 days in the county jail, 1 day jail credit, $400 fine. She has waived her right to a jury trial and call witnesses, and we just asked the court to go ahead and sentence her if that's all right.
Mr. Gill, any objection to that?
No, Your Honor.
Ms. Shipes, did you hear that agreement, ma'am?
Yes, sir. I have a question if I could.
Okay.
Is there a way that I could have the fines in or judgment or whatever converted to community service hours? That's what's gotten me in all this trouble to start with. I've had some converted,
Work
but
it off when you get to jail. Trustee. Ray.
well, they didn't take credit for it last week. Any other time I've done that. That's
First
why I
time
have
you-
all
it's the
these.
First time you're in Jackson County, so.
No, it's
Nothing else, Sean.
Ms. Shipes, did that get your question answered, ma'am?
no, sir, not really, but I'm told it
Okay.
does. So we'll go with
Well,
that.
if you want to ask a question, you can do that. You have the right to
Okay.
do that.
The reason my license is suspended is because of financial obligations to the court. Now, I know that not all of them were in Jackson County, some were in Washington, but I've had them converted to community service hours in almost every case, and I can't prove that because of probation and the way they keep their records. I've been trying to get this settled with Washington County Court for almost a year now. I thought that I did not realize, I thought that it was fixed. So I'm apologizing to the court for that. I understand
It's
that
okay,
you're
Miss-
quiet, but I
so-
need to know.
You know what I'm saying?
Let me take a shot at Mr. McDaniel. So Ms. Shipes, the difference is this has nothing to do with probation. In the
Right.
jail, our jail, if you qualify for our trustee program, which I certainly have no problem with you going to, I don't see any reason why you wouldn't. You would work at the jail or in an assigned program. That counts as community service hours. That's what Mr.
Okay.
McDaniel's saying. You would have these done before you ever finish the jail sentence, as long as you get in the trustee program. The only way you would finish the jail sentence and still owe money is if you don't get in the trustee program or something. That's basically it. You don't get in the trustee program, then you're going to get out and you still owe the money. So if you obey the jail rules, the jail's going to put you in a work program somewhere either inside or outside the jail, and you would get credit for community service while you're doing that program. So it's different than going to a nonprofit agency in the community and then having to get proof of it. You'll actually do them in the jail at the jail's direction, either working in the laundry, in the kitchen. You may be assigned to the courthouse. They're different programs. Ms. Shipes, does that answer your question?
That's what I'm trying to avoid. Yes, sir.
Is this the plea you would like to enter, ma'am?
Yes, sir.
Ms. Shipes, I'm going to accept your plea of no contest to the charge of driving while license suspended or revoked knowingly. I'm going to judge you guilty of that offense, ma'am, sentence you to 60 days in jail. You have credit for 1 day that you've served. I'm also imposing the court costs and fines of $400, which are set by state and county law. Ms. Shipes, if you get those worded off at the jail, like I've just mentioned, they'll be taken care of. If you don't, there'll be a civil judgment for you against those for that amount. Ms. Shipes, if you don't get them worked off for some reason, ma'am, and if there's a civil judgment against you, 90 days from your release date, if there's no payment agreement reached with the clerk's office, ma'am, then they have to send that to, they have to basically start the process of suspending your license. So if you don't get them worked off at the jail, you need to contact the clerk's office when you get out to work to set up a payment plan, and they'll do a payment plan as low as they divide it up into a year. They'll divide up into that a year. But if you get it worked off at the jail, you don't worry about it. It's over. You don't have to deal with it at all. Ms. Shipes, do you have any questions? All right, ma'am. Wish you the best. Thank you. Mr. McDaniel, anything else from the public defender's office? I've got an issue I want to talk to y'all about, but anything else on the record, Mr. McDaniel?
No, Your Honor.
Corporal Brown, anything from the jail?
No, Your Honor, that's it.
And Mr. Gill?
Nothing.
And we can stay on the record. I don't mind at all. So here's my question. So Mr. Gill, here's the question. Let's assume for the sake of argument that Mr. McDaniel is 100% accurate on this 60-day rule, which is my preference. Let's assume that. Let's put something in place to assume that he's accurate. That means there's got to be some type of monitoring system in place to monitor individuals who are on 60, who have been 60 days charged, arrested, not in jail, just arrested. Whether they post bond or not, it's irrelevant. And there's no way there's no way I can know that if they charged or not. The only people that would know if they're charged are the clerk's office and the state attorney's office. And the state attorney's office is the one making that charging decision. So do you have any suggestion, or you may want to talk to Ms. Jeffcoat and put some thought into how can we keep track of people that are coming up on like 55 days so that I don't want, I couldn't care less if you charge or not. That's y'all's call, but I do care about protecting the community. And if a judge put a condition of no alcohol or no contact, that judge felt that it was necessary and important. And I'm concerned about the state effectively overriding the judge by doing nothing. That's my concern. Mr. Gill.
Judge, I need to sit down with it. I know that it's brand new since July 1st. I have not spent enough time with it, and I will, and I'll let the court know exactly when I talk to Ms. Jeffco what our position is.
Okay.
But yeah, I think it is concerning. I mean, ultimately, it has been in the past that on a ROR type of an information hasn't been filed, the defense files a motion, and then that motion within a certain amount of time, there's a hearing on it unless the state cures it or has a showing of good cause why there was a delay. That's always been kind of the past. I need to read this. I don't know if that's still kind of in play, but it has always been incumbent on the defense to file that motion. If they don't file it, then we just all kind of proceed without it.
And I understand Mr. McDaniel's position is his reading of the wording is saying that it's not their responsibility. It's kind of automatic. And there's the first two parts look like it is automatic on the release.
Right.
But subsection 2, I've already put my logic on the record. So I just want to make sure some kind of tracking mechanism in place, Mr. Gill. So if you'll talk to the other prosecutors and perhaps Mr. Bassford, and let's come up with a plan to keep up with these cases. Again, I understand there are times where you're waiting on a lab result, and you want to give the defendant the benefit of the doubt and not charge them until you get the fingerprint result or what is the substance really what the law enforcement officer thinks it was. I understand that, and it may take more than 60 days to get those results. But in the meantime, if you've got a condition of random urinalysis or no contact or no alcohol, I don't want that condition to go away if the judge felt that it was relevant to protect the community or keep the alleged person out of trouble. That's my concern. Mr. McDaniel, you about to say something?
I was just going to say my interpretation of it, this is stuff that's ex parte, between the judge and, the state. And I know it's just judge's responsibility to protect the due process rights of the defendant. And that's what that's about. And the state can obviously file, a motion, with good cause, and the state would make those determinations. It doesn't appear like, there's any situation here because public defenders officers are not appointed to represent them yet. And a lot of times these people don't have attorneys. And I think that is just a due process thing that they've set up in place for, the judge to make sure that they monitor the due process rights of the people.
And see, the problem is that the public defender's officer was appointed for first appearance purposes. And the 40-day rule, the public defender's office for the last 20 years has been tracking those. That's how they get out. That's how people get out of jail. Your office comes to the judge, usually the circuit judge, and says, Judge, it's been more than 40 days. Please sign this order for release. In this case, if the state wants bond conditions to stay in effect, the state needs to take some action, is what I'm saying, Mr. Gill.
I haven't reviewed this, but is this only for alleged misdemeanors? Is this address felonies? I mean, I need to look at it, but
no, it's both. It's both. Now, the rules are different because misdemeanors, there may be a way to charge without the filing of an information. I mean, that's what it's talking about when it says without the filing of information.
Or in case of alleged misdemeanor.
Yeah, so it's both. So we'll try to figure out a system. Mr. McDaniel, in the meantime, if there's any rulings that says I've misinterpreted that statute, we obviously need to get Mr. Peoples back up and correct that. But for the day's purposes, I think that's a reasonable interpretation that I'm putting forth. But thank you to all of you.
Just to let you know, I know you said for the last 20 years, Jackson County has done this. To my knowledge, we're the only county that does that. I know because I get grief from the people at the office about having to do it because every other place, they don't do that. They do it. I think they've always done it.
So how do they get out? If your office doesn't do anything, which is your position, how do they get out of jail?
I think when you read the rule says the court's supposed to do it.
I'm asking you mechanically, not what you think the rule says. Mechanically, in other counties, if you say that, and I don't know that I agree with that, but mechanically, how does the person go from being behind bars to out of bars if the public defender's office never does anything?
I
in
haven't talked
Washington,
with,
Holmes, Jackson, Bay County?
I haven't talked with those counties to see how they
Yeah.
operate.
So what I
Your
think
Honor.
happens is the public defender's office prepares an order and sends it to the judge, and the judge signs it, and they're released. So I think that's what happens in every county, not just Jackson County, Mr. McDaniel. And if I'm wrong about that, you can let me know tomorrow, but I think you're gonna find out that's the way they do it. And somebody's got to prepare the order. I feel like that's what happens. The public defender's office tracks them. When Mr. Glass was here, there's zero doubt he did it.
Oh,
And,
yeah, I'm not saying
since
they
he's-
didn't. Yeah, and I know we'd still do it, but I hear the complaints because they say no one else has to do it, from the staff involved in our office, so that's the
You
reason I
know
say
how
that.
much weight you know how much weight that means to me, how much weight I give that, their complaints, but I appreciate y'all. Hope y'all have a great day, and we'll see you.
All rise. This report is now in session. I will let Kenny County preside.
You see it, please. All right. People against Richard J. Godfrey, 25F244515. Come up to the podium. Krista Cole, have a seat at the table. Harley Wykosh, have a seat at the table. Come on up to the podium, sir.
Good morning, Your Honor.
Your name? Your name?
Richard J. Godfrey.
All right. You haven't been drinking this morning, have you?
I'm sorry?
You haven't been drinking this morning, have you?
No, sir.
So if I give you a PBT right now, it's gonna come up clean?
Yes.
All right, we're gonna just double check that. Have a seat right there. I'm gonna have them give you a PBT,
I'll
okay?
put it right here.
First row. Krista Cole, come on up to the podium. Krista Lee Cole, 25F244368 A and B. Your name?
Krista Lee Cole.
You're charged with driving on a suspended, ma'am, and you also have a second charge of disobey a traffic control device. You have the right to a lawyer. I'll be happy to give you one at public expense if you would like. Would you like a lawyer?
No, thank you, Your Honor.
Okay, so I'll go ahead and arraign you and we'll go from there, all right? It is alleged that on July the 12th, July 12th of 25, that you're operating a motor vehicle in Breland or Hall in Flat Rock, and that you did disobey a traffic control device, a construction zone sign, count one, that's a 2-point civil infraction. You also have driving on a suspended, which is punishable by up to 500 fines, 93 days jail, costs, or all of those in 2 points. Do you understand that?
Yes, Your Honor.
I don't think you have a PBT. Did you sign the advice? Yep. Did you sign the advice of rights?
Yes, Your
Did you
Honor.
read it?
Yes,
Did you understand it?
yes, Your Honor.
If you plead guilty, you'll be giving up all those rights and there will not be a hearing or a trial. Do you understand that?
Yes, Your Honor.
Okay. You still wish to waive your right to a lawyer?
Yes, Your Honor.
I'm going to enter a not guilty plea for you. I'm going to give you a $500 personal bond. You do not have to post any money. I'm going to send you to the prosecutor. You can talk to the Flat Rock City Attorney. And then either way, you're coming back in front of me. You cannot leave the state without consent. You can't violate a law. You must appear in court as directed. Those are the bond conditions, okay? Do you understand all that?
Yes, Your Honor.
Do you have any questions?
No, Your Honor.
Are you employed?
I work 4 days out of the month,
What is that? Doing what?
waitressing.
Okay. All right, so you go out, we'll set you up. Either way, you'll come back in front of me, and if they don't give you what you want, you tell me, I'll give you a lawyer, okay?
Okay. thank
Good
you.
luck. Harley Quinn Wykosh, file number 25F244090. Your name, ma'am.
Harley, welcome.
You're charged with disturb the peace. You have the right to a lawyer. Be happy to give you one at public expense if you would like one. Would you like one?
No,
I'll go ahead and arraign you on July 11 of 25. It is alleged that you were in the city of Flat Rock, County of Wayne, on Walnut Creek Drive at or near 28521 Walnut Creek Drive in Flat Rock, and that you did disturb the peace. That is a misdemeanor punishable by up to $500 in fines, 90 days jail, costs, or all those. Do you understand that?
yes, sir.
Did you sign the advice of rights and read and understand it?
Yes, sir.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes, sir.
Okay. Do you still wish to waive your right to a lawyer?
Yes.
I'm gonna enter a not guilty plea, $500 personal bond, okay? You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. I'm gonna let you go talk to the city attorney, see if you can work something out. If you can, great. If you can't, then, I don't know what.
Where am I going? I'm sorry.
You're gonna go right out in the hallway, and he's going to take you to the city attorney, okay?
Okay, thank you.
You're welcome. Eads, Christina Eads. 20B138279C, 20B138279A. Good morning, ma'am. Your name?
Christina, yes.
All right, so you have the right to a lawyer here today. You owe $5 on one case. And you owe.
Okay, go back there.
You owe $175 on the other. Is that what these are up for, Lisa? It's show cause hearings on each of these?
Yes, show cause for non-payment.
All right. Do you have the money?
Not today.
How much do you have today?
Thank you.
Okay. Here's what I'm gonna do. Where do you work at, ma'am?
I work in Probable. It's a company called Probationary.
I'm gonna waive the balance on, the $5 balance on 2OB138279A. You owe $175 on the other file. You pay $50 now. When can you pay the rest?
3 months,
3 months.
like $50 a month.
How much do you make in your employment?
How much, I make $18 an hour.
How many hours do you work?
40.
You're asking for a lot. Are you married, kids,
Yes,
both?
yes,
Does your husband work?
yes.
Why?
We have bills and we're behind right now. We're trying to catch up.
You gotta come talk to me. Right? This has been going on since March of 24 when I sentenced you. You were supposed to pay it that day. I don't know why it wasn't paid that day. I'm gonna assume I addressed it subsequent to that date. You're asking for a lot. I mean, I don't mind working with you, but come on. You pay $20 bi-weekly. I'll do that. When do you get paid next?
Next week.
All right, you pay $20 bi-weekly beginning August the 18th. Do you think you can do that?
Yes.
Now, if you don't have the money, you have to come talk to me. Call the court, we'll go on Zoom, okay?
Okay.
Or else come in here on or before your due date. So go down and pay the $50 on the one and you're all set. Good luck. People against Godfrey. Let's find out, John.
I gave you a sticky note there.
Richard J. Godfrey, 25F244515. Okay, so you registered zeros. Good. Your name?
Yes,
Your name?
Richard J. Godfrey.
You're charged with disorderly conduct, public intoxication. You have the right to a lawyer. If you want, I will give you one now, or I will arraign you and let you go talk to the prosecutor. It's your choice. Hey, sir, come here. Come on back in here.
I'm sorry.
You're talking on the phone, right?
I was answering my attorney trying to walk out.
You got your phone into the ear. Please don't do that. Not in the courtroom. Okay?
Yep.
Thank you. So, you're charged with disorderly person, public intox. It is alleged that on July 23 of 25. So I guess I need to ask you that first question. Do you want a lawyer?
No.
They think that you were publicly intoxicated July 23 of 25 at 3:04 PM on Arsenal near West Huron River Drive in the city of Flat Rock. That is a misdemeanor punishable by up to $500 in fines, 90 days jail, costs, or all those. Do you understand that?
So, what is the fine, $500?
These are the maximum penalties provided by law. That's what I have to tell everybody.
Okay.
I didn't say I was sentencing you to $500 in fines or 90 days jail or costs or all those. I didn't say that. Those are the possible penalties. Okay?
Yes, sir.
Do you understand that?
I do.
Did you sign this advice of rights?
Did I what? I'm sorry, I'm hard of hearing.
Okay, that's all right. This advice of rights form, did you read it?
Yes, I did.
Did you understand it?
I do.
Did you sign it? You signed it, right?
This here?
The advice of rights form.
Yes.
If you plead guilty, you'll be giving up all those rights and we're not going to have a trial. Do you understand that?
Yes, sir.
Now, do you want a lawyer?
No, I can't afford one.
Well, I told you I'll appoint you one if you want one. I'm gonna enter a not guilty plea for you, first of all.
Okay.
I'm gonna give you a personal bond. You don't have to post any money, okay?
Yes, sir.
$500 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. No alcohol, no illegal drugs. You're not to purchase, possess, or consume any one of those. And that's where I'm gonna go from here. If you want a lawyer, I'll give you one. Otherwise, I'm gonna send you to the prosecutor to talk to him.
I don't know what to do, to be honest with you.
It's up to you. If you
I
want,
guess I need a lawyer.
I'll give you a lawyer. Have him go talk to the prosecutor. Not guilty, please entered, okay?
Yes, sir.
All right, good luck. We'll see you back in here either way today. You understand that, right? Yes, sir.
Okay.
Don't go anywhere today until we're done. Okay?
Okay, can I go out to my truck or?
He wants to talk to the prosecutor, Your Honor.
He wants, we're gonna give him a defense lawyer.
Okay. Just have a seat in the hallway.
And we're gonna set you up with the lawyer that will then talk to the prosecutor, see if they can resolve this. Either way, whether they can or can't, you come up here back in front of me, okay?
Yes, sir.
All right, good luck. Hilario Romero Chavez, 25T718463. Your name, Detective?
Detective Sergeant Mark Driscoll, Trenton Police.
Okay, raise your right hand. You solemnly swear affirm under
Have a seat in the hallway.
Okay.
solemnly swear affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole truth, so help you God.
Yes, Your Honor.
Go ahead.
On June 7th, 2025, at approximately 0238 hours, Trenton police officers were dispatched to the area of 3rd Street and Atwood in the city of Trenton, County of Wayne, for a male asleep behind the driver's seat of the vehicle. Officer Evan McLeod arrived on scene where he observed a white 2011 Ford Fusion bearing Michigan license plate 3 Lincoln Union X-ray 52 facing south in the roadway, stopped partially in the intersection. Officer McLeod observed a male later identified as Hilario Romero Chavez, a Hispanic male, date of birth of 2/28 of 1983, in the driver's seat sleeping. Officer McLeod observed the vehicle running with the keys in ignition and Mr. Romero Chavez's foot on the brake pedal. Officer McLeod and Officer Erica Ducky placed the vehicle in park and awakened Mr. Romero Chavez, where they observed a Modelo beer can in the cup holder and smelled a strong odor of intoxicants emitting from Mr. Romero Chavez. Officer McLeod had Mr. Romero Chavez exit the vehicle where he observed him unsteady on his feet, having bloodshot and glassy eyes, and his speech was slurred. Mr. Romero Chavez provided his Guatemalan identification card. Officer McLeod again could smell a strong odor of intoxicant emitting from him. During Officer McLeod's questioning, Mr. Romero Chavez spoke both English and Spanish. Officer McLeod requested Mr. Romero Chavez to perform SFSTs, to which he replied no. Officer McLeod read Mr. Romero Chavez's PBT rights verbatim from the Trenton Police PBT advice of rights form, and Mr. Chavez refused and then was arrested. Officer Blake Rusnick arrived on scene and assisted with the inventory per the Trenton Police impounded vehicle policy. Officer Rusnick located a cellophane bag containing a white powdery substance and white powdery substance on the driver's seat. Upon returning to the Trenton Police Station, Officer Rusnick tested the substance using the mobile detect multi-drug test kit, which revealed a positive indication for cocaine, and weighed the substance, which revealed 0.1 grams with packaging. Excuse me. Officer McLeod transported Mr. Romero Chavez to the Trenton Police Jail, where he read his chemical test rights verbatim from the DI-177 form, which he refused to provide a breath sample. And Officer McLeod completed the DI-93. Officer McLeod authored a search warrant for Mr. Romero Chavez's blood, which was reviewed by APA Suchman Bothell and authorized by Judge Coleman Hudson. Mr. Romero Chavez was transported to Henry Ford Hospital at Brownstown where Art and Jennifer Finley utilized the Michigan State Police blood kit, drew 2 1cc vials from Mr. Romero Chavez's right arm. On June 9, 2025, I sent the Michigan State Police blood kit via priority mail to the Michigan State Police Forensic Lab for testing. On June 18, 2025, I received Michigan State Forensic Lab report TX 25-7973, authored by forensic scientist Stephanie Grabowski, which revealed Mr. Romero Chavez's blood alcohol was 0.213. Additionally, I checked Mr. Romero Chavez's vehicle and Michigan driver's record through Link, which revealed he had no insurance and never obtained a license. On August 5th, 2025, I received Michigan Crime Lab report NV25-976-1, which was authored by forensic scientist Daniel Case. The lab report identified the narcotic substance as cocaine.
Based on your sworn testimony, I find the crime possession less than 25 grams of cocaine. Super drunk, OWI, and drive while suspended, revoked, denied were committed. There's probable cause to believe the crime was committed by the defendant. You must have sent this over yesterday. This is dated August the 6th. I changed in the date. We haven't done the signing on record today, August 7th. I'll initial that. I'm signing and dating the complaint and the warrant for the arrest of the defendant. Have a good day. Thank you. Paige Bondi, Paige Kathleen Holiday Bondi, 25D715-702. Good morning, Detective. Your name?
Good morning, Detective Jeff Claft, Brownstown Township Police Department.
Raise your right hand. Do you solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole true self you got?
Yes, sir.
Okay, go ahead.
On February 27th, 2025, at approximately 11:06 p.m., Officer Washburn and Officer Fox were dispatched to 19001 Telegraph Road in Brownstown. That's the BP gas station. They were dispatched for reports of a driver passed out behind the wheel of a burgundy Ford Flex. Upon arrival, Officer Fox observed the burgundy Ford Flex parked next to one of the gas pumps with the driver's side door open. Officer Fox also observed a black male, later identified as Cortez Martin, in the driver's seat slumped over the center console. The front seat passenger of the vehicle was a white female, later identified as defendant Paige Bondi. Officer Fox made contact on the passenger side, while Officer Washburn made contact with Mr. Martin on the driver's side. Officer Fox asked defendant Bondi if they were under the influence of any drugs. Defendant Bondi admitted to consuming mushrooms. Defendant Bondi's speech was mumbled, slurred, slow. Her eyelids were low and appeared heavy, and she was acting very lethargic. Officer Fox looked down near her feet and observed a glass bulb meth pipe with burnt residue inside lying on the floorboard of the car. When asked defendant Bondi if she had any drugs or pipes in the vehicle, she told Officer Fox no. When Officer Fox asked her about the meth pipe by her feet, defendant Bondi tried to place her foot over it and hide it. Officer Fox told defendant Bondi to exit the vehicle. Defendant Bondi exited the vehicle with her purse in hand. When asked if Officer Fox could make sure defendant Bondi didn't have any drugs in her purse, she told Officer Fox yes. During the consent search, Officer Fox located a loaded hypodermic needle with the cap on it. When asked if there was any heroin or methamphetamine inside it, defendant Bondi said both. As Fox continued to look through defendant Bondi's purse, Officer Fox located what appeared to be a folding card holder. Inside, Officer Fox located several pieces of suspected crack cocaine rocks. Officer Washburn placed defendant Bondi in handcuffs and placed her in the rear of the patrol car 1813. Officer Fox continued to look through the contents of the purse. He located a small clear plastic baggie with suspected heroin inside and a small blue metal vial with suspected methamphetamine inside. While searching the vehicle, due to the meth pipe being in plain view, Officer Fox observed a small colored pouch bag sitting on the dashboard directly in front of the passenger seat where defendant Bondi was seated. Upon looking inside the bag, Officer Fox located a second glass bulb meth pipe with burnt residue inside. He also located a glass stem crack pipe with chorboy and burnt residue inside, and a second loaded uncapped hypodermic needle with a red and brown liquid inside. Mr. Martin requested medical attention. Our fire department arrived on scene and transported him. Officer Washburn located a folded up gum wrapper with Mr. Martin's person. When Officer Fox unfolded the wrapper, he observed a tan brown powder substance consistent with heroin. Defendant Bondi was turned over, Mr. Martin was turned over to Brownstown Fire Department for treatment. Defendant Bondi was arrested and brought back to the Brownstown Police Department. Evidence that was collected was the suspected crack cocaine, methamphetamine. A field test was completed with positive indication. The loaded syringes were not field tested due to the hazard of testing them. The heroin recovered was also not tested. On 4/21/25, Detective Attard conveyed all controlled substances to the Michigan State Detroit lab for further testing. On May 1st, 2025, lab results from the Michigan State lab were provided. Recovered from Mr. Martin's person, it was identified as 0.3982 grams of fentanyl. Recovered from defendant Bondi's purse, it was identified as 1.0734 grams of cocaine. And recovered from defendant Bondi's purse, it was identified as 0.2747 grams of methamphetamine. Defendant Bondi shows prior convictions on February 7, 2018, assaulting, resisting, obstructing a police officer, pled guilty on 9/6/2016, obstructing by disguise, pled guilty 10/4/2016, malicious destruction of property, and 9/24.
They did not include a habitual offender notice.
Oh,
so you
okay.
don't
I'm
think
sorry,
you-
Your Honor.
those, but I'll go ahead and authorize, I'll note that you signed this yesterday. I'm changing the date of the signing on record to today, and I'm initialing it. There's probable cause to believe the crimes of possession of less than 25 grams of cocaine, possession of meth, and possession of heroin/fentanyl were committed. There's probable cause to believe those crimes were committed by the defendant. I'm signing and dating both the complaint and the warrant for the arrest of the defendant. Thanks a lot. Have a good day.
You too, sir. Thank you.
Curtis Amati. Call in Beth on this. I need Elizabeth Wilds on this. This is People Against Curtis Brent Hamadi, file number 25R513926A.
Good morning, Judge. May I get turned down for Mr. Hamadi? Hamadi, state your name for the record.
Curtis Brent Hamadi.
So Ms. Wilds checked into this, and I'm going to let her explain this. This was all over the other convictions out of Arizona and Florida, and at least it appears as though he had the conviction out of Arizona from '99, the conviction for OWI in February of 12 out of Florida. Excuse me, but the other one from 2012 out of Arizona, we could not verify. Your name?
Elizabeth Procedural.
So can you repeat that? Is that true? He's got 3 convictions on his precinct.
I'm sorry, Judge. It's the 99 conviction that would be substantiated.
Well, he's got 3 on here, right?
Right. It's the one from 1999 that we had an issue with. That's why it was adjourned twice already on this to verify that. And then also, Mr. Hamadi's, there is no conviction out of Florida as well, Judge.
Well, wait a minute. Why don't you tell me what you did?
Yes, Your Honor. Yes, we could go ahead and kind of extensively look at the record. And because of the sex registration, Florida is reporting the Arizona offenses. So he is correct. So what's occurring is on the Florida driving record, it is showing a conviction for drinking and driving, and it's also showing on the Arizona CCH. It is the same offense. That is out of Arizona, and that is the 2012. On his Michigan driving record, it is showing a conviction for the 1999 OUIF. But what catches your eye is the fact that the arrest date and the conviction date are both from, I believe it's March 19th, 1999. But it is indicating that that conviction was by default, the same as the 2012 that Mr. Hamadi admits and is also on his CCH. That also reports back at the Michigan driving record by default. So the question at hand, is the 1999 a conviction or not? I ran his Arizona driving record. I ran his Arizona CCH along with Florida, along with Michigan. I can't find it on any criminal history. I can only find it on the Michigan driving record entered as a default with, again, the same arrest and conviction date.
So in your view, how many prior convictions does he have? It's not the 99 one. He doesn't have that.
Correct. I'm seeing the 2012 out of Arizona, and then I believe this would end up being his second offense.
So not that there are two in 2012, one out of Arizona, one out of Florida. You're saying
those are the same.
Right.
Yeah.
So he's got only one prior drunk driving conviction as far as you can tell, and that is in June of 12, correct?
That is correct, Your Honor. That's the only one I could confirm.
Okay. Okay. Give me 1 second, please.
Sir, you gotta take your hat off.
All right, now we had a problem with the prints, by the way. I don't know what happened. This is what I read. Paramus P, defendant needs to be printed again. Called defendant and advised to get printed at Gibraltar before sentencing. Did you do that?
Yes, Your Honor.
He did, Judge. I verified before today.
All right, so do you have any questions of Ms. Wiles before I let her go? I'm gonna count this as him having one prior OWI or impaired conviction, and that is the 2012 OWI, it appears, but not the 99 and not the other one.
Correct, or neither is the one in Florida, Judge. That one was just.
I understand. So we have one prior OWI conviction and that's it.
Correct.
Besides these others that are not drunk drivings.
Correct.
So, anything else?
Nothing further, Your Honor.
You can go ahead and go. Thank you very much.
Thank you.
Are there any material additions? So with that, and I'm going to strike it just for the record, I'm going to cross out the OWI and I'll say excluded. And then, so I'm modifying the report in that aspect. And then also the the February of 12 case excluded, and I'll initial that. What, is everything else in this report accurate?
Everything else, Judge, appears to be accurate, correct.
Is there anything you'd like to say on his behalf?
Just that Mr. Hamadi is 51 years old right now, and he owns his own home renovation company. He has a 13-year-old child who lives with him, and he just recently reconciled with his wife. They've been separated for a number of years. So he's in the process of getting his life together. If you notice the dates on a lot of those convictions, Judge, those were prior from Mr. Hamadi's past. Let's say when he was younger and not as smart as he is today. And I would let the court know that he's taken responsibility for everything that he's done. He's tried to make amends. Obviously, he's not run away from his problems. He's faced his consequences, got through it, and is trying to move on, Judge. And we'd ask the court to take that into consideration, as well as the fact that this will be the third time that we will be before the sentencing on this case, Judge.
Anything you'd like to say?
Your Honor, just that I know that I've made a lot of mistakes, and I'm too old to be doing this, and I just want to do the right thing and move forward and take care of my family and be a positive member of the community. And I apologize to the city of Rockwood and to this court. And I just want to move forward as best way as I can, Your Honor.
Additionally, Judge, if I may, Mr. Hamadi is also taking initiative to start the Victims Impact Panel program. So he's making good faith, positive efforts towards getting a lot of the stuff that he needs completed.
You're still getting yourself into trouble. I mean,
There's no reason that I should have been driving.
yeah, but it's not just that. You had, in 21, even, that's 3.5, 4 years ago, but you had a criminal trespass in Florida. You had a larceny in the second degree out of Florida. I mean, it's time to grow up.
I understand, Your Honor, and the trespassing was involving my daughter who I was living with me, and I just promise you that I didn't intend, for any of that stuff to happen. I made a lot of bad choices, and I need to make better ones, and I apologize to this court.
I believe, Judge, also the larceny charge was the fact that there was an issue between him and his daughter. He took the phone away from her. And he ended up getting charged with larceny.
18 months probation. You cannot leave the state without the consent of the court. I'm not sure how you're working and still collecting government assistance. They're saying you're collecting bridge card money.
Because my work has been pretty non-existent. I haven't worked too much in the past couple months. 18
months probation. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those. Kratom, poppy seeds, and CBD oils are prohibited. If you consume food or other items that contains those substances, that will be deemed a violation. Submit to chemical testing PBTs and ETGs as follows. Bi-weekly for 3 months. If you're clean, I'll make it monthly for the duration of probation. Attend AA, twice a week until you're in outpatient treatment. My court officer is going to give you a form. You have to go in person. Every time you go, you have to have that form signed. Every time you come to probation or to court, you have to bring that form with you. You have to go twice a week until you're in outpatient treatment. Once you get in outpatient treatment, you no longer have to attend AA or NA. Attend the Victims Impact Panel, which is one night put on by Mothers Against Drunk Drivers. You're to serve, he spent 1 night in jail on this, right, counsel?
I believe so.
4 days jail credit, 1, serve 3. I'll let you serve the other 3 on the court work program. There's a $35 a day charge for that for a total of $105. Pay $300 in fines, $250 costs, $75 victim's rights fee, $50 justice assessment, $675 in fines and costs, including the mandatory fees. You have $60 screening fee for $735. You have probation fees of $360. Bring your total to $1,095. They're $20 a month, and then you have cost of recovery of $225 for a total of $1,320 plus court work program fees. Your total should be $1,425. Would you double check that, man, please? So if you violate, your probation could be revoked. You could be incarcerated for 93 days. You have 21 days to appeal, and you have 14 days to apply for a court-appointed lawyer for purposes of appeal if you cannot afford one. Do you understand that?
Yes, Your Honor.
Do you have all of this to pay? How much does he have, Mr. Gates?
Judge, he needs a payment plan.
Does he have anything today?
I don't believe so, Judge.
I don't, Your Honor.
How much can you pay per week?
Can I do $50 or?
A week?
Probably swing that.
You need to get back to work.
I do.
$50 weekly, beginning August the 25th. If you ever need more time, you call the court. We'll go on Zoom on or before the due date. Or you can come in and talk to me on or before the due date, 8:30. I'll be more than happy to give you an extension. Please don't ignore me, okay?
Yes, Your Honor.
You'll meet with probation before you leave. Any questions?
No, Your Honor, only that I heard you mention no marijuana. I am a medical card holder. That was the only thing.
Yes, you do have a medical marijuana card. I won't violate you because the law doesn't, well, it makes that inappropriate if you test positive, so long as you possess and provide proof to probation of a valid medical marijuana card, okay?
Yes, Your Honor.
Good luck, thank you. Stay out of, you gotta get your life in order though. Good luck. Krista Lee Cole, 25F 244 368 A and B. Ms. Cole, come on up here, ma'am, and I will take your plea. Your name?
Christina Lee Cole.
All right, so you're gonna plead to allowing an unlicensed driver to drive. And then they're going to dismiss the suspend, revoke, deny. And you are going to also give a dismissal of the disobeyed traffic control device, right?
Yes, Your Honor.
Is that what you want to do?
Yes, Your Honor.
If you do that, possible penalties are up to 500 fines, 90 days jail, costs are all those. Do you understand that?
Yes, Your Honor.
And did you sign, read, and understand an advice of rights form here today?
I did.
If you plead guilty, you'll be giving up all those rights, and there would not be a hearing or a trial. Do you understand that?
Yes, Your Honor.
You have the right to a lawyer. Do you still wish to waive your right to a lawyer?
Yes, Your Honor.
To the charge of allowing an unlicensed driver to drive, how do you plead?
Guilty.
Were you in control of a 2016 Ford that was being operated on Vreeland near Holland Flat Rock at 7:29 PM on July the 12th of 25?
Yes, Your Honor.
And you were unlicensed. Actually, you were revoked at the time, were you not?
Yes.
Anybody forced you to plead guilty?
No, Your Honor.
Are you on probation or parole?
No.
All right. You got your license back out of Ohio and then you blew the restrictions? I mean, the restricted license, is that right?
No, Your Honor. In Ohio?
Let me just check this. Did you ever live in Ohio?
No, Your Honor.
Administrative amended due to Ohio Circuit Court ruling on October 10, 19. Not consume intoxicants, no alcohol or drug related activity, may drive to and from your residence. Oh, that. Okay, I see. All right. You're going to get a valid license now, right?
Yes, Your Honor.
You got to do that though, okay?
Yes.
What else do you want to say? Anything else?
No, I'm just currently in the process of getting my license back. I have 2 kids getting ready to go to preschool and I have to get my license back. So I'm doing everything I can to get that. I'm almost there. I just have to finish a couple more things up.
All right, 100 fines, 200 costs, 75 victims' rights fee, $50 justice assessment, 4 1/4 of 90 days. Again, for the record, the revoked, dismissed, and the disobeyed traffic controlled. Wait a minute. He's also got you pleading to impeding. My apologies. You're pleading to impeding traffic, true, and then he's dismissing the traffic control device, correct?
Correct.
To the charge impeding traffic, my apology. Responsible or not responsible?
Responsible.
On that charge, I'm in charge of 150 dismissed. So the please accepted to allowing the licensed driver to drive, please accepted to impeding. The suspend, revoke, denied, and disobey traffic control device are dismissed. 425 or 90 days on the allowing unlicensed driver to drive, 150 on the impeding, 575. Can you pay that today?
I can pay 400 today.
Okay, you pay this impeding now, that's 150. You pay 250 now on the allowing unlicensed driver to drive, and how about if I give you until August the 31st to pay the rest?
Yes, Your Honor.
Okay? If you need more time, call the court, we'll go on Zoom, I'll give you an extension, okay?
Okay, thank you.
Best of luck, thanks.
Judge, can we do Mr. Arnie's case?
I got it right here, Timothy James on, 25F2439938. Why is Mr. Ani in a hurry? Or?
He actually got a job across the street at Family Dollar, and so he's took some time off.
Gone an hour at the most, and I've been waiting out here since 8.
Well, you didn't need to come here at 8. We don't even open the doors
I
till.
wasn't sure what time you guys open or not.
Yeah, I don't have a problem. Your name?
Timothy Ani.
All right, so he pled guilty to operating while impaired. The OWI was dismissed. He was referred for screening and assessment. Have you had a chance to review the report with him, and are there any material additions, corrections, or deletions?
Good morning, Nancy Gate, appearing behalf of Mr. Arnie. But I've had a chance to review the pre-sentence report, Mr. Arnie. No material changes, corrections, or additions, or deletions here.
Was the other driver still on scene when the officer came aboard? Came on scene?
I honestly can't recollect. Tell you the truth.
You didn't really have a cat run out in front of you, did you?
No.
You just told the police officer that? Was it a one vehicle accident? I know it was a dirt bike.
It was a mini bike, Judge.
Yeah, I'm sorry, mini bike.
Collided.
Pardon?
Me and my friend collided. I was on one and he was on another one.
Is he okay?
Yeah,
You were okay?
yeah. Besides a headache, it took about 2 weeks to go away.
All right, what else? Anything else?
Just that Mr. Audi is 31 years old. He just actually started his job today. He works at the Family Dollar, right across the street from the courthouse.
Okay.
Judge, he has no significant criminal history other than there was out of the 25th District Court back in March, which is, he had a warrant issued and he didn't know about that until we actually informed him about it the last time he was here. He's in the process of taking care of that. Judge, Mr. Audi doesn't really get in trouble. This was a one-off. This was a situation where his friend had purchased these mini bikes. They had a little too much to drink and they were just driving and got into an accident between both of them. No one was hurt, and I just chalk this up to carelessness at this point.
I made a mistake that I won't ever do again. I've always tried to stay out of trouble because my mother was a disabled American veteran. I didn't have a father growing up, so she was kind of both a mom and a dad. She passed away a few years ago, and that's when I really started drinking randomly, to tell you the truth. Before then, I didn't really like drinking. The only thing I can say is I made a mistake, and I promise I won't ever do it again.
Okay, good enough. 6 months probation. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You change your address, place of employment, or home telephone number, you have to notify probation. You have to report as directed. No alcohol, no marijuana, no illegal drugs.
I haven't done
Hang on.
anything.
Kratom, poppy seeds, and CBD oils are prohibited. If you consume food or other items containing those substances, that will be deemed a violation. I'm in order that you attend the educational level 2 alcohol education program with the Victims Impact Panel. I won't order court work. 3 days jail, credit 1, serve 2. I'll let you serve those by way of community service. 2 days community service, that's to be completed by September the 20th. So you got about 6 weeks or so to complete your 16 hours of community service. 300 fines, 225 costs, 75 victims' rights fee, $50 justice assessment. So fines and costs here are $650, screening fees $60 for 710, probation fees are $120 for 830, cost of recovery is $150, your total is $1,080. You may be eligible for early discharge if you're compliant, get everything done, and in 3 months you could apply for early discharge. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. At least you're showing some humility. I do want you to clear all your outstanding warrants, though.
No, I understand.
Clear all outstanding warrants by September 20th as well. You understand?
Yes, Your Honor.
Okay.
Judge, Mr. Audi is going to get payment.
How much does he have today?
He doesn't
Anything?
have anything today. He just started his job.
It's fine. Can you pay $50 a week, you think, or no?
Yes, sir.
You pay, are you sure?
Yes.
$50 weekly. I'll start that beginning on September the 5th. If you don't have the money at any time, you call the court. We'll go on Zoom. I'll give you an extension, or you can walk in here on or before the due date. I'll be glad to give you an extension, okay? Good luck to you. You'll meet with probation. If you want to tell them that I said it's okay if you schedule again to come back, if you got to get to work, no problem, okay?
Can I get a copy of the paperwork?
Yes, they're going to give it to you when they instruct you,
Mr. Audi, just go across.
okay?
Thank you.
Good luck to you. Is Kelly Ferguson here?
Yes. Come on.
Kellyanne Ferguson, 20R 511-787. Kellyanne Ferguson, 219R 511-211. Good morning. Your name?
Kelly Ferguson?
Good morning, Judge Mazengate, here back from Ms. Ferguson, is the concept.
Let's talk about the assault case. You pled no contest back on June 26th. You were in the hospital. We adjourned the sentence, et cetera. There's an issue with the printing.
There was an issue with the printing, Judge. I believe Detective Mercure was here the last time, and he did advise that Ms. Ferguson had gone into the station to get printed, but they did tell her that her prints were already on file.
The point is, did she go back and did we resolve that? Has that issue been resolved, or I still need her to? Well, there is one here. Hang on one second.
I believe they do have.
July 14th of 20. Let me check something here.
Judge, she's just like Mr. Hamadi. She needed to get reprinted, but her phone number doesn't work. So I mailed her a letter, but she didn't do it.
Where do you live?
Church Street, Marble.
I need you to get printed. I need you to get printed.
Yeah.
Did I cover this in front of Detective Mercure last?
Yes, this is the third time Ms. Ferguson's been before.
I know, but did we not tell her to go get printed? Did I not tell you to go get printed last time?
No.
I don't recall.
Well, I don't see how this is,
Judge, at the last hearing, we were unsure what happened, so I looked into it. Realized both of them had to get reprinted, but I could not get a hold of Miss Ferguson, so I had to mail her a letter.
Right, okay. I don't have a problem with sentencing her now, but part of the sentence is going to be that she has to get printed on the assault charge. She pled no contest to assault back on June the 26th. I did not order a pre-sentence report on that charge. So what do you have here, counsel? What do you want to do?
Judge, I've reviewed the pre-sentence report with Ms. Ferguson.
Now, remember, there was only one on the child endangerment that was 19R 511211.
Correct. Judge, with the assault case, I believe that was the case that was is that the 2019, or sorry, that's the 2020 case, correct, Judge?
Correct.
The reason she pled no contest to that, first it was, was 5 years old. Additionally, at the time, I believe she was just getting through some surgical procedures and she was on medication that maybe hindered her ability to correctly recall the events of what happened that day.
Okay, that's fair. That give me 1 second. I just need to check one thing here. If you can give me a second. You know, I don't even know who they're listing as the victim here. They have both the officer and a Quinn Parker. I mean, it's just a strangely written report, or at least I can't add everything up. They say She was arrested for assault on both, and they only charged one count of assault, and they don't indicate who it is. I believe it was Mr. Parker, though. Is she still seeing Mr. Parker?
Yes.
What's your relationship with Mr. Parker now?
We live together. We have 2 kids together.
All right, what else would you like to say, counsel? I can handle both of these at the same time. The one's got a child walking around. You got to get your, like,
If I may, Judge, not to cut you off, that issue, according to Ms. Ferguson, that was the time she had bladder reconstruction surgery.
she was intact, she was under the influence.
Not at that time, Judge. No, she was actually under the influence of medication. She had just finished surgery for bladder reconstruction. She was under the assumption that her partner was going to be at the residence. He ended up leaving and going to work. She was in bed recovering. Next thing she knew, the officers had woken her up and told her that her child had gotten out. But she was under no, she didn't know prior to that her partner was going to leave. She thought he was going to be there to care for the
It
child.
appeared the reporting officer Ferguson was under the influence of some type of narcotics. Trash and numerous toys were scattered around the floor of the home. Dirty dinner plates on the table with food scrapes and flies on them. Curdled milk, foul odor in the home. She said, "Don't tell me he went out the front door again." Again, he reiterated Ferguson was under the influence of some type of narcotics. No food in the refrigerator.
Again, she was in the process of, she had some number of medical issues and she was being treated for that. She had just gotten out of surgery.
Where was the father at? Where was Mr. Parker?
He went to work. He wasn't supposed to go to work. I just came home from the hospital the day before. I was in the hospital for a month with the surgery. I was on Tramadol. That was the only medication I was on for pain relief that I was prescribed from the hospital.
The 2022 case, possession of narcotics out of the 24th District Court. What kind of drug was that?
What district?
24th District Court, Allen Park.
That was cocaine.
Okay. And you got a warrant out for possession of drug paraphernalia out of the 16th in Livonia.
Yes, I
Ms.
was.
Ferguson, if you're gonna have children, and you have them, you need to take care of them.
No.
You need to make sure that children cannot get out the front door, and that child was how old again at that time?
It was almost 3.
All right. You cannot allow your children out. CPS was involved, everybody else was involved. Do you have a mother or father in the area?
No, I do not.
What else do you want to say, Counsel?
Judge, just that, currently right now, she's not working due to her situation. She's currently also going through a number of medical issues, Judge. Right now, she's not working, but she is in school for cybersecurity. Hopefully she would have, well, at the time the report was written, she would have graduated or finished in, I apologize. She started a program for cybersecurity through Kaplan University, Judge, in July, and she's due to finish in January of next year. She does have 2 minor children, Judge, like you stated. Obviously, she's doing her best with the circumstances that she's got. She has no family around her, so she does depend a lot on her partner. And Judge, just that, she's trying to make good choices and trying to deal with, what she's got going on medically. So we ask the court to take that into consideration.
Do you get me?
Yes, Your Honor.
Anything else you want to say?
Just that I'm trying to get my life back together.
Okay,
I know I messed up in the past.
okay. So you gotta do that though. When we bring children into the world, you know who's the best position to raise them appropriately with ethics and values and integrity and everything else? It's not the system, it's the parents. You can't let your child go walking out of the house.
No, they deserve it. They deserve the best.
12 months probation. I'm sentencing you on the child endangerment/neglect first. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, place of employment, or home telephone number, you must notify probation. You have to record as directed, no alcohol, no illegal drugs, no marijuana. You're not to purchase, possess, or consume any one of those. You're to submit to chemical testing, PVTs and ETGs monthly. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. You have to attend a parenting class and provide proof of completion. You're to clear all warrants by September 30th. I'm going to order that is there a reason you can't obtain employment?
I am undergoing for renal cell carcinoma.
Okay, I'm going to delete that requirement. Fines 100, costs 100, 250 in probation, 240 in probation fees, 75 victims' rights fee, $50 justice assessment fee, $60 screening fee. So I'm going to add those up and they're going to come out to $625. I won't even charge you attorney fees. If you violate, your probation could be revoked. You could be incarcerated for 90 days. You may be eligible for early discharge if you get everything done. Do you understand that?
Yes, I do.
Now, on the other file, I'm simply going to say to you, 6 months probation. I won't charge you probation fees. I won't charge you a screening fee. You cannot leave the state without the consent of the court or violate any law. You must appear in court as directed. $100 fines, $100 costs, 75 victims' rights fee, $50 justice assessment. You have to be printed and photographed by the end of the day. You have to go for your prints by the end of the day. There's to be no assaultive, abusive, or intimidating behavior toward the victim, Quinn Parker, or assaultive, abusive. So Lisa, we're going to lift any no contact provision. I think Judge Heston made it the officer, and I'm fine, but I want to make sure those bond conditions are lifted as it relates to that. I'm also going to order on each one of these cases, and I will run them concurrent, that you serve 3 days of community service. I'm going to give you until October the 20th to complete that. 3 days of community service, 24 hours community service. I'm going to order that on each case, but community service hours concurrent between 2 OR 511787 and 19 R 51121. Do you understand that? So you only have to do 24 hours of community service, and that'll satisfy both. Okay?
Okay.
All right, now, so you owe 6 1/4, plus I'm going late on this other one, 3 1/4, or 90 days. I'm gonna let probation to set up terms of payment with her, Lisa. We're gonna do that on both of these. Probation to set up terms of payment, so you'll meet with them today, and they will set up your payment terms, okay?
Okay.
And if they give you a schedule that you can't fulfill, all you have to do is call the court and come talk to me, or walk in here on or before the due date at 8:30. I'll be more than reasonable with you. Please do not ignore me, okay?
Okay.
You seem like a nice lady. You gotta get your life in order.
I'm trying to.
How old are you now?
34, too old to be.
You got 60 more years ahead of you, presumably. Let's do this. Let's make sure these kids are raised appropriately. Most important thing we do in life is raise kids appropriately. I don't care what anybody says. Everybody talks about money and success and all these other nonsensical, frankly irrelevant things, and then the most important one we tend to forget about. Good luck. I wish you well. I really do. Best of luck.
Thank you.
Willis, Teresa Marie Wills, 25F256707.
Good morning, Judge. Investigators appearing back from the school.
I don't know what we did. This was agreed to be taken under section 771.1 by the prosecutor. I'm fine with that. She never got printed either, so I'm gonna have to order her to go get printed. Ma'am, your name?
Teresa Wills.
I don't see where there was any agreement on restitution. Mr. Gaith.
Judge, I was trying to recall.
I mean, it looks like I see something about 4769, and then I see something about 4280.
Those are there was a number of transactions.
I know, so I'm trying to figure out what, is anybody here at all from the victim from Myers in Flat Rock?
I believe the police chief should have had a note on this with regard to the restitution.
I don't believe it did, but I will double check that. Yes, it's restitution to be determined. Call in Mr. Cayley. It's 249. And there was an agreement here that it be taken under 771.1 with the provision she be placed on probation for a period of 12 months.
Correct.
Okay, let's just see what he has to say. First of all, I guess we can start. Did you review the screening and assessment or the pre-sentence? And are there any material additions, corrections, or deletions?
We have reviewed it, Judge. It's actually accurate. We have no omissions, corrections, or deletions.
Good morning, Mr. Cayley. Your name?
Morning, Roger Cayley, P. 4101, Baffin City, Flat Rock.
I'm trying to figure out what the restitution is here. It said restitution to be determined on the STIP form. I see a couple different transactions. Would you take a look at this, please?
Sure.
And you can take the police report and see what you can find out. It was from the Flat Rock Myers there on Freeland. And if you can let me know, I'd appreciate it.
Sure.
So, ma'am, is there anything that you would like to say?
I made a mistake and I didn't mean to do what I did as far as like, I didn't know it was wrong, just put it that way. I didn't know what I was doing was as bad as it was. Just because there was other people there showing me how to get refunds and all that stuff, and they were doing the same thing, so I wasn't thinking.
They were stealing too?
If I may, Judge, there was other co-workers, according to Ms. Wills, that were doing the same thing, and they had encouraged her to also participate, Judge.
That's
And
nice.
she made a mistake, and obviously.
What if they,
lapse in judgment.
so what if there's a bunch of you, they're going in and robbing banks? You're gonna let them convince you to do that too? Seriously?
No,
This is not appropriate.
it won't happen again, I promise.
Well, I know, but somebody entrusted you enough to hire you. And then you turn around and stole from them, and whoever these ringleaders are, I hope they get caught. To be perfectly candid with you, they're encouraging people to steal. What is becoming of this society? How much did you steal?
It was, they said it was $197.
Do you agree with that? I can either set a restitution hearing, or we can, or you want to agree with the 197. It's up to you. I can set a restitution hearing and have the people come unless you can tell me. Mr. Cayley, your name?
Roger Cayley, City, Flat Rock.
What'd you find out?
On this case, it looks like it's $42.80.
And there was something else for $46.79 on there. I'm not sure what.
There was two other cases. There was two other case numbers, complaint numbers, so I don't know what happened with those.
Have they been adjudicated? Have you been in court on any other cases so far?
They were all out of the same St. Myers, they were all out here.
Well, I know, but did she get prosecuted on the other ones though?
I believe the agreement that we came to was part of the global settlement on this.
Oh, okay, so if those other cases were dismissed, then we still need the restitution.
Right.
Yeah, I hear it, Judge. 4769 as well.
So what is the total? You got 47?
4280 and 4769.
And then there was the third transaction, Judge, I believe it was like 112.
So is 197 pretty accurate?
I believe so, Judge. I believe that may encompass the entirety of the amount.
Do you agree with that, ma'am?
Yes.
Okay, good enough. That's what I'm gonna order. That's what I was a little bit confused about. Did I let you finish? Is there something else you'd like to say?
Judge, just that Ms. Wells is currently working at a temp agency now, so she is trying to get back on her feet. She does have no prior criminal history besides these matters before you, Judge. She understands what she did is wrong. Obviously, she's remorseful for what she did. It was a lapse in judgment, Judge, and she listened to other people that were basically doing the same thing that she's here before you on. And now she wants to obviously abide by what the court sentences her, move on and put this behind her. Is that correct, ma'am?
Yes.
All right. Anything else you'd like to say, ma'am? Embezzlement is worse than theft to me because, like I said, somebody entrusted you. They hired you. They believed in you. And whoever these characters are, they're encouraging co-employees to start stealing from their employer. Really. 12 months probation. You cannot leave the state without the consent of the court or violate a law. If you change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. You're not to enter 26100 of Vreeland or any other Meijer store. You're not to have any contact with employees of the Flat Rock Meijer. You're to be printed and photographed at the Flat Rock Police Department by 1 p.m. today. I am taking this under 771.1. You're to serve 2 days of court work program, $35 a day, total 70, and 8 hours of community service. I'll give you until September 30 to complete your community service. That's at any nonprofit organization. But you have to have that done, and then they're going to schedule you 2 days on the court work program. Fines 100, costs 175, victims' rights fee $50, justice assessment $60, screening fee. So your fines and costs here amount to $385 with the screening fee plus $240 is $625 plus court work program fees is $695. Your total here amounts to $892. That includes restitution to Myers of $197. If you violate, your probation could be revoked. You could be incarcerated for 90 days. You have 21 days to appeal, and you have 14 days to apply for a court-appointed lawyer for purposes of appeal if you cannot afford one. Do you understand that?
Yes.
So I'm going to order you. I'm filling out a separate print order, Lisa. I'm going to have them go to the Flat Rock Police Department by 1 p.m.
Do I have to pay for that?
No.
Okay. So I don't get paid till tomorrow, so.
You have to go there by 1 p.m. today, and we're going to give you a review hearing date to come back and have your case dismissed, presuming that you qualify or that you are compliant. What do you have for me on that, Lisa? Should be, what, February or?
Oh, I thought you said 12 months.
I did, thank you.
Okay, July 30th of 26 at 9 o'clock.
July 30 of 26 at 9 o'clock, okay?
Judge, Ms. Wills will require.
Yeah, how much can you pay today? Anything or not?
No, I don't get paid till tomorrow.
How much you get paid? How much can you put in weekly or bi-weekly?
I can do $50 a week is fine.
$50 weekly. And I'll start that beginning on Monday, which is the 11th, okay? If you ever don't have the money, no problem, call the court, we'll go on Zoom. I'll be glad to give you an extension, okay? Please, 650, 710, 830, 980. She's right. She's right, yeah.
So hold on, Ms. Wills.
Did you hear me, Lisa? You said you're.
Can you say that louder? I'm just kidding.
Was there a change in the amount?
No, that was on another case.
Oh, okay.
No, that was on another case. You're all set. You gotta go meet with probation though.
Yeah, she's going to.
Ray Ann Cray. 25F244329.
Good morning, Judge. Nice to get the print out from Ms. Cray. Ms. Cray, state your name for the record. Ray Ann Cray.
All right, so. You been going to test weekly?
Yes, I have.
Have you been testing negative? I can't hear you.
Yes.
Are you sure?
Yeah, I haven't been. using
Okay.
any drugs.
And you got your AA 3 times a week?
Yes.
Let me see it. You can show it to your lawyer, okay?
Okay.
Go ahead. Back up.
All right. Have you had a chance to review the report with her? And are there any material additions, corrections, or deletions?
I have had a chance, Judge, we have had a chance to review the report. It's actually accurate. We have no omissions, corrections, or deletions, Judge.
All
And I
right,
did verify her AA form, Judge. She has been attending that.
good. Anything that you want to say on her behalf?
Judge, just that Ms. Cray is 50 years old. She is receiving social security benefits because she is disabled. She's currently working part-time in addition to that. The income she receives from social security, she's working at McDonald's on a part-time basis. Just to be able to just kind of get out of the house and keep moving. She does admit that she does have an addiction, Judge, and she is in the process of trying to get help for that. And she understands that at her age, this is not something that she should be doing. So she does understand that this is something that she needs to get under control and so that she can move on and have a positive impact. Is that correct?
Yes.
All right. Is there anything that prevents her from working on the court work program?
Physically, I don't believe so, Judge. No.
Ma'am, you were all over the road this day. You know that? You gotta be careful here, okay?
Yes, sir.
Anything else that you want to tell me, ma'am?
Nothing other than I'm just, I've had, on and off drug problems for years and, mental health issues, and I'm trying to get it all under control.
Well, let's try to get, let's try to get that taken care of, okay? I'm serious.
Yes.
For 16 months probation, you cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed: no alcohol, no illegal drugs, no marijuana. No alcohol, no illegal drugs, no marijuana. You're to submit to chemical testing, PBTs and ETGs. I'm going to order it weekly for 5 months, bi-weekly for 2, then monthly. Weekly for 5 months, bi-weekly for 2, then monthly. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. You're to attend the Victims Impact Panel. You're to attend AANA 3 times a week until you're in intensive outpatient treatment. So I'm ordering intensive outpatient treatment. I'm ordering the Victims Impact Panel. Once you get in intensive outpatient treatment, you no longer have to attend AA or NA. 4 days jail credit 1, serve 3. I'll let you serve those by way of the court work program. $35 charge for that, for a total of $105 in court work program fees. You have to clear all of your warrants by the end of September. September 30 is the cutoff. Clear all of your warrants. You're to pay fines in the amount of $300, cost $200. 75 victims' rights fee, $50 justice assessment, 6 1/4, screening 60 for $685. Probation fees are $320 for $1,005. You have attorney fees of $40 for $1,045. Cost of recovery of $225 for a total of $12.70. I don't think I included the court work program
You
fees.
did not, Judge, no.
So you got $13.75. I want to double check that. It should be $13.95, right, Lisa?
I got $13.75.
I was right the first time. $13.75. I'm gonna let you pay this, ma'am. Do you have any money today?
I don't have all that, but I
Yeah, we can put up today, man.
I got like 100.
Okay, you pay for 100 now. You think you can pay $50 a week then?
Yeah.
I'll make it 35 a week and I'll start that beginning August 18th. 35 weekly. If you don't have the money at any time, you call the court. We'll go on Zoom on or before the due date, or you walk in here. I'll be glad to give you an extension, okay? Just don't ignore me. All right?
Yes, Your Honor.
I wish you well. Let's get this under control. I'm not sure I shouldn't get you in the sobriety court. You gotta get off of that stuff, okay? Stay off of it. I know it's not easy, but you're gonna die if you keep using that. Good luck. I wish you well, I really do. Brandon Misselif. Brandon Christopher Misselif, 4F242829. Is this yours?
No.
Which one do you?
No problem, Your Honor. You can handle that. I have a Koshi though.
Okay, find that file.
Not in any rush. Thank you, Judge.
Find that file for me, will you? Koshi. Your name, sir? All right, you're charged with failure to refrain from consuming alcohol or drugs, testing positive for THC on July 15. That is the charge. If you're found guilty, that would be a first technical violation by law. The most you could get is 5 days in jail. I'm not saying you would, but that is the maximum. Do you understand that?
Yes.
And did you sign, read, and understand the advice of rights?
Yes, sir.
You plead guilty, you will be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes, sir.
All right, now you have the right to a lawyer, and I'll be glad to give you one at public expense if you want. Do you want a lawyer? Are you sure?
Yes, sir.
Okay, I'm gonna ask you how you plead now. To the charge, you failed to refrain from consuming alcohol, testing positive for THC on July 15, 25. How do you plead? Did you consume marijuana or THC, say within the 1 week preceding that date? Sir?
Yes, sir.
Anybody forced you to plead guilty?
No, sir. I do have a medical card as well, sir. I just didn't have.
When did you get that?
I had it when we started probation. I just didn't have a physical copy of it. That's why I didn't give it to.
Well, you didn't tell me about it.
I didn't know.
I would have allowed you to do that, not because I like it, but because I think that's fair.
Right, and
Hang on, slow down.
Yeah, I'm sorry.
Slow down. Let's call in Emily and have her bring the screening report, and I'll go from there, okay?
Yes, sir.
So did you have a valid medical marijuana card on July the 15th?
I don't know if it was on that day. It came around that. I had gone to the doctor because they told me that.
I sent you June 26th.
Correct.
Did you have a valid medical marijuana card on June 26th?
I have the email right here. I can pull it up and see what the date is on it, and I can give you a correct.
Yeah, I don't want you to guess.
Right.
All right. Should we have on that?
You didn't tell me.
No, sir. No, I did not. I
Why didn't you tell me? If you had one, why didn't you tell me? If you didn't, I know why I did what I did. And I'm asking, do you have proof that you had a valid medical marijuana card on July the 15th?
That's what I'm trying to find. Let me try.
Mr. Misselhoff, I'm gonna go on to another case. You can pull that up and tell them to show it to Emily, John, when she comes in. Okay, you can have a seat, sir. Eric Allen Koshy, file number 25F2438180D.
Right, Your Honor. And good morning, Sean Mansour, on behalf of Mr. Koshy, who's approaching.
Come on up here, sir. Your name?
Eric A. Koshy.
All right, so your client pled guilty to operating while visibly impaired. The screening and assessment was prepared. Have you had a chance to review that report, and are there any material additions, corrections, or deletions?
Yes, Your Honor. We have had a chance to review the report, Mr. Koshy and I. There are not necessarily any additions. The only correction is there's a medication that's misspelled. It's really a non-issue, but it has one letter off. Outside of that, there are no other issues.
Which one's that, by the way?
It's Farxiga. I think that on the form it's FARXIG.
Right.
There's an A, it's Farxiga.
Okay. Emily, it's on the other case. You're fine right now. I went on to another case.
Can I wait or you want?
Yeah, no, you can wait right there. So what would you like to say? Anything else? I'll modify the report in that aspect. Anything else you'd like to say?
As it relates to the report, no, Your Honor, but I would like to say some things on that.
Sure.
I will say my client is 60 years old. He has no prior criminal history whatsoever, Your Honor. This is his first run-in with the law. He is employed full-time as an engineer. He's not your typical probationer. He obviously made a terrible decision that he's looking to put past him. Your Honor, he was extremely forthcoming and cooperative during the incident. I just want to make that clear. And he's had no issues with alcohol, or he's never had issues with drugs. But he has no issue with alcohol either. Outside of that evening, since he's been placed on bond, he's had no positive tests, no violations whatsoever, Your Honor. I do want to talk about a trip that he's taking and ask the court for a travel request. And then I do want to talk about his driver's license restriction. I know Mr. Koshy wants to say a few things on his own behalf as well, Your Honor, Judge, if you allow.
Sure. What do you want to say about his driver's license restriction?
I don't know if this court has any authority over it, but essentially it's restricted until October 10th.
I can't do anything.
But what I will ask is, his son is getting married in Montana on the week of September 23rd. I just asked the court to allow him.
Congratulations. With marriages come grandkids. With grandkids come happiness, I feel.
Yeah.
We're taking two up north with us this weekend.
I have 6 grandchildren.
Congratulations, I got 5. What do you have to say? Anything?
Yeah, I just want to apologize for even being here, Your Honor. I made a really poor decision on May 3rd. I'm just looking forward to taking care of the task that you're going to give me and moving on from this.
One last thing for me, Judge. Would you consider a review hearing at some point during his probation?
I didn't even say I was placing him on probation. Go ahead.
If he's placed on probation, Your Honor, I would just ask the court to consider. I just think he's going to be a great probationer if placed on with no violations and have all his requirements.
There's a presumption that I'm not supposed to place somebody on probation. Again, I don't necessarily agree with that, but I don't write laws. I'm just here to follow laws. He's 60 years old. He's never been in trouble. He scored in category 2. I'm not going to place you on probation. I'm going to assess fines of $300, costs of $300, 75 victim's rights fee, $50 justice assessment, $60 screening fee, for a total there of $785. You have cost of recovery to Flat Rock of $150 that you have to pay through the court. Pay $935, do 2 days of community service. I'm going to give you until September 20th, and I also want you to attend the Victims Impact panel. Otherwise, so you're not on probation. You're just going to do 2 days community service, Victims Impact. Since you're not on probation, you don't need permission to leave the state. You owe $935, 2 days community service, and Victims Impact panel. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer, or 93 days if you violate. Do you understand all that? Can you pay that today?
Okay.
Probation will tell you where you can do your community service. They'll set you up on the Victims Impact. I wish you well. Good luck with your kid.
Thank you so much, Judge.
Thank you.
Thank you very much.
You're welcome. Misselhoff, Brandon Misselhoff. Brandon Christopher Misselhoff, 24F2422829. Your name, Ms. Tissino?
Liz Tissino.
Your name? All right, so he said he has a medical marijuana card. He didn't, hang on.
I got it.
I asked him if he told us at the screening. I
He
think
didn't get it till after sentencing, so I don't know how you want to handle this.
When did he get it? Before July 15th or after?
July 10th. Yeah, it was issued July 10th, so he was sent.
You gotta get permission to do this in the future, okay?
Yes, sir.
All right, I'm gonna go ahead and dismiss the show cause, not because I like all this medical marijuana stuff, but I'm just telling you, I'll dismiss the show cause, but you gotta have a valid medical marijuana card, show cause dismissed. And I'm gonna just add, you can prepare this on an order, defendant not to be violated, if positive for THC, so long as he possesses a valid medical marijuana card. So long as he possesses a valid medical marijuana card. That doesn't mean you can't be prosecuted under federal law, but under state law, that is my order. I wish you well. Good luck. Thank you very much. Thanks, Mr. Sino. All right, now. Wacash. Harley Quinn Wacash. 25F244090. Your name? All right, so you're going to plead to disturb the peace with the plea to be under section 771.1 for 3 to 6 months, true?
Yes.
If you plead guilty here, the possible penalties are up to 500 fines, 90 days jail, costs are all those. I'll take it under that statute. I'll place terms and conditions on your probation. If you're compliant, at the end of that specified period that I set, the case will be dismissed. Do you understand that?
Yes.
And again, did you sign, read, and understand and advise the rights form here today?
Yes.
If you plead guilty, you will be giving up all those rights and there will not be a hearing or a trial. Do you understand that?
Yes.
All right. You still wish to waive your right to a lawyer?
Yes.
To the charge disturb the peace, nice and loud. How do you plead?
Guilty.
Were you at Walnut Creek Apartments July 11 at 25 at 1:46 p.m.?
Yes.
What did you do?
That was my move out day. I moved in, I don't know what year.
What were you doing to be disorderly?
I was in the process of moving out. My parents were helping me move out. They had U-Haul outside. I was inside. A lady who has been harassing me went out there and was arguing with my parents again. So I walked outside and I seen her arguing, so I started yelling at her to get away from my parents, and then that's when police said.
Are you on probation or parole?
No, I've never.
Anybody force you to plead guilty?
No.
Please accept it. I'll take it under section 771.1. I don't need a probation report.
Can I say something?
Hang on, not yet. I do want you to go and get printed and photographed today, okay?
I should have.
Just listen to me.
I have friends.
You're gonna go over and get printed on this case by the end of the day, okay? You have to go over to the Flat Rock Police Department. I'm giving you till 2 p.m. today. I don't need a pre-sentence report. I do not need a pre-sentence report. We'll give you a sentence date. I'll take your plea and I'll sentence you on that date. What day will you got for me?
September 4th at 8:30.
September 4 at 8:30, okay? Do you understand?
No, I do not. So what is happening right now? I'm on probation now?
I'm taking your plea. I'm setting it for a sentence date.
Okay,
I want to read the report.
okay,
I want you to go get printed today
okay,
at Flat Rock. We're going to give you an order. You're going over to Flat Rock. You're coming back on September 4th at 8:30, and I will sentence you then.
okay.
Okay? I already explained your bond conditions. They are in effect now until you come back for sentence, okay?
Okay, so where do I go right now? Just Flat Rock Police Department?
You're going to go down the hall, get your notice, and then you go over to the Flat Rock Police Department.
Okay, thank you.
Okay? Good luck.
Thank you.
You're welcome. Terrence Arnold Boyd. Is he here? I'm sorry, Terrence Arnold Hall, rather. Terrence Hall.
He's right there. I don't know where Mr. Crawford went. I told him to come in here.
The disappearing act. Kennedy Tamoy Campbell, 24F2423331A and B. Your name? Your name? Where you been? I gave you extensions on this already. This is 2024 case. I said pay 50 per week beginning May the 6th. Did you pay anything other than one day on May 23rd? You paid 50? And then it looks like, yeah, did you pay anything other than that?
I believe I paid twice.
Did I or did I not tell you that if you didn't have the money that you needed to come and talk to me? If I didn't, if you were one of the last 287 people that were in front of me and the one that I forgot to tell that to, then tell me. I'll go listen to the tape.
No, you didn't tell me.
Then why didn't you do that? Now we got to show cause you again.
Because I thought I'd be able to just come to court and work something out.
I told you to come and talk to me if you didn't have the money. You didn't do that. What, do you think I'm lying to you?
No.
Where do you work?
Right now, I currently work at the dental office.
What do you do?
Dental assist.
How much do you make an hour?
18 an hour, but I only work about 15 hours a week.
Then maybe you need to get a second or third or fourth job.
Yeah.
15 hours, I'll probably be working 15 hours when I'm retired. That isn't enough to support yourself.
Yeah, I have interviews today for a second job.
How much do you have today?
How many interviews I have today?
No, how much money do you have today? Ms. Campbell, don't take advantage of my good nature here. I told you what you needed to do. I don't tell people that for my health or because I want to hear myself talk. You pay 50 today, balance at rate of 40 per week. I'll cut it down, beginning August the 18th. Lisa, she's then going to pay, that's on the B file, and you can set up a payment plan however you want to do it with the A file. Same thing. Now, if you don't have the money, you can do one of two things. You can come in here on or before the due date at 8:30, or if it's more convenient, you call the court and say, can I go online with the judge on Zoom and ask for an extension, in which case I will grant it if we have to do that once, twice, 4 times, 74 times, or 139 times, okay?
Okay.
Don't ignore me again. I don't like it, all right?
Am I able to do community service?
You make a couple, 3 payments, and then if you want to do community service and you don't have any better employment, you come in here and talk to me. Lisa, you'll remember her and I having this conversation. I'll be glad to let you do community service on the rest.
Okay, thank you so much.
Don't ignore me again. Good luck. Thank you. People against Hall. Terrence Arnold Hall, 218G303-179. Why do people make their lives so difficult here? Your name?
Mike Crawford representing Mr. Hall.
Your name?
Terrence Hall.
He was supposed to show up for a sentencing in front of Judge Kirsten 7 years ago. Close to 6.5 years ago on a no ops, like that was a big charge. And he didn't show up. Why?
Well, he had a major life change, Your Honor. He had become homeless during that time period in that little gap. He was living out of his van, looking for some work. He was going through that for a few years, trying to stay warm, just keep a roof over his head. And honestly, and he'd be honest about it, through those struggles, he just kind of lost track of this. So.
Where does he live now?
Well, Your Honor, now he's got some things in order. I want to update the record. He lives at 25226 Oxford. He's got a home now in Woodhaven. And
25226 Oxford?
Yes, sir. In Woodhaven. And his phone number is 734.
Hang on 1 second.
Okay.
Okay, go ahead.
734-925-3442, Your Honor. My client was working at Amazon here recently up until May the 28th. They downsized and terminated him. He's on unemployment now, but he's willing to set up a payment plan. He wants to take care of this now that he's been reminded about.
Well, how long has he been in custody?
He just got picked up earlier today, Your Honor. Allegedly, they allege that he had had a traffic violation. He was on his way to try to initiate his social security benefits, Your Honor, because he needs money to survive.
Maybe I should have him sit in jail for about 60 days. I could set a bond that he probably can't make. You can't do this. You can't do this. You can't not show up for 7 years. I mean, it begs the question as to what somebody thinks they are, who they think they are. This is a no-ops. This is ridiculous. You deserve to have been pulled over on Friday at about 2 o'clock where they'd keep you for 3 days. Maybe you'd learn a lesson. His record's not bad. I'm gonna sentence him. I'm gonna pretend this didn't happen. Is there anything else?
No, Your Honor, I just want to say thank you for this opportunity to take care of this time tightly.
Listen to me. I'm gonna be fair with you. You do this with me again, I'm gonna lock you up on a no-ops. Do we understand one another? Do you want to tell me anything before I sentence you?
Do you want to say anything before being sentenced?
100 fines, 100 costs, 75 victims' rights fee, $50 justice assessment, 325 or 60 days. He's working at Amazon now, right?
No, Your Honor, he just got let go in May, he's on unemployment.
Oh, I see. Can he pay 40 a week?
What he'd like to do to get it over with, Your Honor, we can set that, but he can pay $250 every 2 weeks, starting August the 15th.
I'm gonna let him pay 40 per week beginning August the 18th. How's that?
You better, Your Honor, just wanted you to know he's serious about taking care of this now.
Take care of it. If you need more time, all you have to do is call the court. We'll go on Zoom. I'll give you an extension. Please don't ignore me again, because then I'm gonna get nasty. We understand one another?
He said you understand it.
Yes, sir.
All right, good luck.
Thank you, Your Honor.
People against Godfrey. Richard J. Godfrey, 25F244515.
Sir.
Good morning, Your Honor. Peter Bernardo, P78413, and MIDC for the defendant.
Sir, your name?
Richard J. Godfrey.
This is going to be a plea under section 771.1 as charged with the understanding he'd be placed on probation for 6 months, that the case will be dismissed if he's compliant. True?
Yes, sir.
Is that what you want to do, sir?
Yes, sir.
If you plead to that, the possible penalties are up to 500 fines, 90 days jail, costs are all those. Do you understand that?
Yes.
And you signed an advice of rights form here today, true?
Yes, sir.
If you plead guilty, you'll be giving up all those rights and there will not be a hearing or a trial. Do you understand that?
Yes, sir.
To the charged disorderly person, public intox, how do you plead?
Guilty.
Were you in the city of Flat Rock, county of Wayne, on Arsenal near West Huron River Drive at 3:04 p.m. on July 23 of 25?
It was actually 10:30 in the morning.
Okay, they're saying 3:04 p.m. But at some point you were on Arsenal in Flat Rock, July 23?
Yes, sir.
What did you do that makes you guilty of public intoxication? Did you pass out or something?
I tripped and fell. You couldn't get back up.
Ah, because you were drinking?
Yes.
You consumed how much that day?
Maybe a half a pint.
Anybody force you to plead guilty?
No, sir.
I'll accept your plea. I'll take it under 771. I'm going to refer you for a screening and assessment. Mr. Godfrey, I mean no disrespect. I mean no disrespect. I could tell when you walked up here, you got a drinking problem. Now, we can do something about it or we can let it go. If we let it go, you are the ripe old age of what? 64. I don't think you're, what's that?
I said, yes, sir.
I don't think you'll make 67. I saw the way you walked up. I'm just telling you. So it's up to you. I'm gonna let you think about it.
Okay.
I think I can help you. Give me a sentence date, Lisa. So you're gonna undergo a screening and assessment. You're gonna fill out a questionnaire and be interviewed. I've already set the bond conditions. No alcohol, no illegal drugs. I want you going to AA, NA at least 3 times a week. 3 times a week. Give him a form, John. Give me a sentence date. Is it gonna be September 4th, Lisa?
Yes, 8:30.
September 4th at 8:30. I'm not saying you're a bad person. You seem like a very nice man,
Thank you.
but you gotta get off of this stuff. What's that Ohio State Buckeye jersey doing on? Huh?
I asked him if you were a Michigan fan.
No, I'm a Notre Dame fan,
Oh, there you go.
but they lost to him in the final. Good luck. Wish you well.
Thank you, Judge.
Stay out of here. I don't want to see you till September 4th.
December 4th,
September 4th.
September 4th, what happens then?
I'm gonna sentence you. You're gonna go down the hall, get your notice. And then you're gonna go across the probation where you'll fill out a questionnaire and be interviewed, okay?
Okay.
Good luck.
Thank you,
Thanks.
sir.
How we coming?
Got a couple more silent records across town when you're ready.
I'm ready.
Oh, you're holding.
Do you mind seeing him real quick? He just wants a new payment plan.
No, no problem. We aim to please here at the 33rd District Court.
You just give it.
There you go. Thanks, Judge.
Thank you. Recalling Brandon Christopher Misselif, 24F242829. Your name? I'm sorry. I don't know why I keep saying that's Misselif. What do you want? Tell me what you want. You're paying 50 a week beginning July, right?
Correct.
What do you want?
I'm trying to do, so I'm on the other probation as well.
Just tell me how much you need. You
I
can,
do 75 a month with them. I wanted to see if I do that here as well, because I dropped.
Lisa, modify that. Pay $75, defendant to pay $75 per month. He's on probation for a sufficient amount of time. I'll start that beginning September 1. Can you do that?
Yes.
If you need more money or more time, you come in and talk to me. I'll give you an extension, okay?
Judge, that's a holiday, so September 2nd.
I know, so I'll let you pay the first day after the holiday. The first of every month or before you should pay, okay?
All right.
Good luck.
Thank you.
If you're late on that first one and don't pay till the second, nobody's gonna give you a hard time. Thanks.
Thank you.
Waiting on Brownstown here.
What's that?
Waiting on Brownstown.
Those aren't that big.
Thank you, Scott.
I got a bunch more. Let's just wait till they're all done. I actually got a bunch here. I got it. Let's just wait. Unless he wants to go now.
Is that pretty much the docket except for the trial?
Yeah, it looks like it, Judge.
Can I have? Can I have those? I'll start calling those. Whittle. Timothy James Whittle, 25T645972A. Defendant failed to appear, will issue a show cause he failed to appear for arraignment. Tiffany Beatrice Baldridge, 25F244061. Defendant failed to appear, will issue a show cause. John Christopher Bodart, 25R514202. Defendant failed to appear. 3,010%. Warrant to issue. Bond to be forfeited. Sterling Joseph Wright, 25F244059. Warrant to issue. 3,010%. Michael Bernard Faison Jr., 25F244321. 3,010% warrant to issue, bond to be forfeited. People against: Hartley, Caprice Love Hartley, 25F244380, A and B. Defendant failed to appear. It's got multiple warrants here. It looks like 4,010%. She failed to appear for show cause. And there was already a default judgment entered on the A file back on the 24th of July for disobeyed traffic control device, Austin James Baderi, 25F244428 A and B. On the B file, 3,010% warrant to issue. And on the A file, the default judgment was already entered on the 24th of July. I'll take them. People against Brandon Venarn Flowers, 25B7169041, and also Terrion Quandell Nathaniel Miller, 25B7169042. Your name?
Good morning, Your Honor. Crystal Tulas, Detective, Brownstown Police Department.
Raise your right hand. You solemnly swear or affirm, under penalties of perjury, that the testimony you give in these proceedings will be the whole true self you got.
I do, Your Honor.
Okay, go ahead.
Your Honor, on December 29th of 2022, Officer Tolliver was dispatched to the Brownstown Police Department lobby in reference to a fraud complaint. Upon arrival, Officer Tolliver met with victim Jared Buccarelli, who stated that he had been the victim of a fraudulent transaction that had occurred in the Kroger parking lot located at 23849 West Road in Brownstown Township. Victim Buccarelli stated that he had listed his PlayStation 5 on Facebook Marketplace and agreed to sell that PlayStation 5 to a subject identified as Jason Brown by his Facebook profile. Victim Buccarelli stated that Jason Brown agreed to pay $500 for his PlayStation 5 and agreed to meet Victim Buccarelli in the Kroger parking lot. Victim Buccarelli stated that Jason Brown arrived in the Kroger parking lot at approximately 8:15 p.m. on December 29th of 2022. Victim Buccarelli arrived at Kroger and met with two black males later identified as Mr. Brandon Bernard Flowers and Mr. Terrion Quandell Nathaniel Miller, and provided them with his, Victim Buccarelli provided them with his PlayStation 5 in exchange for what Victim Buccarelli believed at the time were 10 legitimate $50 bills of U.S. currency. Victim Buccarelli stated that the suspect vehicle was occupied by two younger black males with thin builds and that neither occupant resembled the Facebook profile picture of Jason Brown, who appeared to be middle-aged and heavy-set. Victim Buccarelli stated that once the exchange was completed, Mr. Flowers and Mr. Miller left the Kroger parking lot, and Victim Buccarelli noticed that Jason Brown left the chat thread on Facebook Marketplace where they had been speaking and blocked Victim Buccarelli from contacting them again. Victim Buccarelli stated that he left the Kroger parking lot and returned to his home in Flat Rock, Michigan, and once home, he further examined the 10 $50 bills he had received from Mr. Flowers and Mr. Miller. Mr. Buccarelli stated that he realized the bills did not have any watermarks, did not have a money ribbon thread, and did not feel the same as other bills that Mr. Buccarelli had already had in his wallet. Mr. Buccarelli stated that he knew that he had been scammed and proceeded to create a second profile on Facebook Marketplace and listed another PlayStation 5 for sale. He stated that the same Jason Brown profile contacted him via Facebook Messenger and requested to purchase the newly listed PlayStation. Mr. Buccarelli arranged for a second meeting with Mr. Flowers and Mr. Miller at the Walmart located at 14900 Dix Toledo Highway in Southgate, Michigan. Mr. Buccarelli stated that after making the second meeting, he came to the Brownstown Police Department to report the incident and report the scheduled meeting. Mr. Bucarelli said he was able to identify the suspect vehicle as a 2018 Hyundai Santa Fe gray in color. Mr. Bucarelli provided the 10 $50 bills that he had received from Mr. Flowers and Mr. Miller to Officer Tolliver for examination. Officer Tolliver determined that the bills were counterfeit as the bills all shared the same 3 serial numbers. MF 95231488A, PC 45887140A, and PC 45887141A. The counterfeit currency was seized by Officer Tolliver and processed as evidence. Immediately after speaking with Mr. Bucarelli, Officer Tolliver notified Lieutenant Wheeler of the second scheduled meeting between the victim and Mr. Flowers and Mr. Miller, and Detective Brian Ramsey was contacted to assist with the investigation. In unmarked police vehicles, Officer Tolliver and with victim Bucarelli and Detective Brian Ramsey made the Southgate Walmart location to await the arrival of the suspect vehicle. Shortly after the arrival, the suspect vehicle, which was identified by Mr. Bucarelli, arrived in front of the Walmart store, and Mr. Bucarelli received a text from Jason Brown confirming that he had arrived at the Walmart store at that same time. Per the request of Detective Ramsey, Mr. Bucarelli feigned car trouble and requested that the meeting location be changed from the Southgate Walmart to the 7-Eleven store located at Allen and Sibley Roads in Brownstown, Michigan. And Jason Brown agreed to the new meeting location. The suspect vehicle then left and proceeded southbound on Dix-Toledo Highway towards the new meeting location. Detective Ramsey followed the vehicle as it traveled southbound on Dix-Toledo Highway to the Allen Road connector, turned left onto southbound Allen Road. And at that time, Detective Brian Ramsey observed that the suspect vehicle proceeded southbound on Allen Road through Pennsylvania Road, disregarding a red light in the intersection. Detective Ramsey notified marked units in the area of the observed violation, and Officer Dubois secured a traffic stop on that vehicle on southbound Allen Road south of Pennsylvania Road, and Lieutenant Wheeler arrived to assist. During the stop, the driver of the vehicle was identified as Defendant Miller, and the passenger was identified as Defendant Flowers. Defendant Miller and Defendant Flowers both stated that they were headed home to Defendant Miller's residence in River Rouge, which was in the opposite direction of the way the suspect vehicle was traveling. Mr. Miller had 2 outstanding warrants for his arrest and was taken into custody by Officer Dubois. During the incident to arrest, a search incident to arrest revealed that Defendant Miller had 18 counterfeit $50 bills in his left interior breast pocket of his jacket, which were determined to be counterfeit due to the bills having multiple identical serial numbers. Mr. Flowers admitted to smoking marijuana earlier in the day and gave Lieutenant Wheeler permission to perform a consent search of his person. During the search, Lieutenant Wheeler located a large roll of money in Mr. Flowers' right front pant pocket. Lieutenant Wheeler examined the money and determined that the currency was counterfeit due to 3 of the $50 bills having identical serial numbers, which were also identical to the serial numbers that had been provided to Mr. Bucarelli. Lieutenant Wheeler placed Defendant Flowers under arrest at that time. The 15 counterfeit $50 bills found on Mr. Flowers' person and the 18 counterfeit $50 bills recovered from Defendant Miller's person were seized as evidence, as was $1,687 in legitimate U.S. currency found on Mr. Flowers' person. Mr. Flowers' Apple iPhone in a red case and 2 additional Apple iPhones located in the suspect vehicle were also seized as evidence by Officer Tolliver. Defendant Flowers and Defendant Miller were transported back to the Brownstown Police Department, where they were separately interviewed, which was recorded. They were interviewed by Detective Ramsey after signing waivers of their Miranda right. During the interviews, both Mr. Flowers and Mr. Miller admitted to being in possession of the counterfeit currency, but would not admit to being involved in the purchase of the PlayStation 5 using that currency. However, Mr. Miller did admit to being parked at the Southgate Walmart in front of the store, and when confronted by Detective Ramsey about Detective Ramsey's knowledge that Mr. Miller was headed to the 7-Eleven store, Mr. Miller initially denied that he was going to 7-Eleven, but later told Detective Ramsey, if you would have waited at the 7-Eleven, you would have seen everything you wanted. Following their interviews, Detective Ramsey drafted a search warrant, an affidavit to retrieve the information regarding this incident from the 3 iPhones that were recovered. After the warrant was signed and authorized by Your Honor, Detective Ramsey retrieved the phones as evidence and took them to MSP Trooper Sneed badge 1210 to be downloaded via Gray Key. After the execution of the search warrant, Detective Ramsey was provided with a portable drive that contained copies of the files extracted from each of these iPhones, which was saved as evidence. Detective Sergeant Morrison subsequently performed a review of the 3 cell phone extractions in this case. Detective Sergeant Morrison reviewed all 3 phones for evidence from the date of this incident, December 29th of 22, and found that only Brandon's iPhone had evidence of interest from that date. Detective Sergeant Morrison found a few SMS iMessages regarding the sale and purchase of PlayStation 5s on Brandon's iPhone. Detective Sergeant Morrison also was able to determine that Brandon's iPhone had many instances of Facebook use, but did not find any Facebook Messenger messages, leading Detective Morrison to conclude that the user may have deleted Facebook Messenger prior to the phone being seized. However, in the map application, Detective Sergeant Morrison discovered that on December 29th of 22, Brandon's iPhone had searched for 23849 West Road at the Brownstown Kroger and 14900 Dix Toledo Road, the Southgate Walmart, which were the 2 meeting locations set for the fraudulent exchanges that occurred or were scheduled to occur in this case. Detective Sergeant Morrison also observed that the time of the search for each location was in close temporal proximity to when the incidents reported in this case occurred. 7:24 p.m. for the first incident, which occurred at approximately 8:15 p.m., and 10:32 p.m. for the second incident, which occurred shortly before 11:56 p.m.
Okay. Well done.
Sorry about that, Your Honor.
That's okay. That's okay. Based on your sworn testimony, I find 8 counts of UMP estate warrant were committed. There's probable cause to believe those crimes were committed by the defendant. 1 count of false pretense, 200 or more, but less than 1,000. And 1 count of using a computer to commit a crime. You signed the complaint. Court is signing and dating the complaint and the warrant for the arrest of the defendants, Terry Ann Quandell, Nathaniel Miller, and also Brandon Van Ern Flowers. And we'll issue these warrants. They'll be put in the lien. Have a great day. Thank you.
You too, Your Honor. Thank you.
Thanks. People against Brandon McCullers, file number 16F222285A and B. Good morning, counsel. Your appearance?
Good morning, Your Honor, and good morning to your staff. Ferris Haddad on behalf of Mr. McCullers. I appreciate you allowing me to zoom in, Your Honor.
That's okay. Your name, sir?
Brandon McCullers.
So this is going to be a plea to no ops. They're going to dismiss the suspend and marijuana charge, right?
Yes, sir.
If you plead to that, sir, the possible penalties are up to 100 fines, 90 days jail. Costs are all those. Do you understand that?
Yes, Your Honor.
You are presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent, right to a trial by court or jury, right to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you'll be giving up all those rights and there will not be a trial. Do you understand that?
Yes, Your Honor.
To the charge, no valid operator's license on person. How do you plead?
Yes.
Were you operating a motor vehicle on December 3 of valid license with you on your person?
No.
Are you on probation or parole?
No.
Anybody forced you to plead guilty?
No.
Plea is accepted to that no ops charge. The suspend's dismissed. The marijuana is dismissed. Mr. Haddad, I'm going to listen to anything you have to say. I want you to know I'm not in the practice of not agreeing to an adjournment, but this case has been going on for 9 years and he didn't show up for a bench trial. And I just made up my mind. This one's going to end one way or the other. So nothing with you. I just don't appreciate when people do this. That being said, I'm still going to be fair with them. Listen to what I'll listen to what you have to say. We'll go from there.
Thank you very much, Your Honor. No, I completely understand, and I do know that, and I do know the court's reputation of always being fair as well. Mr. McCullers, to his credit, Your Honor, positively speaking, he did walk in voluntarily. A lot of times when these cases get these old, you're not going to see him until they get picked up. So he has a new job. He's a manager at Mr. McCullers. What's the name of the company?
Lindy Gas and Equipment.
Okay.
He's a manager there. He has a brand new job there. He's trying to clean up all these traffic misdemeanors and tickets that he's had looming over him for quite a while. He is also newly married. His wife is a former law enforcement, and I think he's back on the right track. I did speak to him about, I did understand even when I took this case, Judge, that it may not get adjourned. Unfortunately, I did get caught up at another court, but Mr. McCullers was there right on time. I don't think you're going to have any issues with him following the court's orders. He actually had another case with Woodhaven in front of another judge in your court that was taken care of last week. He did make a payment then. He has $100 down with him today. He gets paid again at the end, or he'll get paid at the end of the month with his first paycheck, I believe.
He has a bond here, and I'm not gonna exceed the bond.
Oh, okay, wonderful, wonderful.
Okay?
Thank you, Your Honor.
Anything else?
No, Your Honor.
Hard fines, 135 costs, 75 victims' rights, $50 justice assessment, 360 or 90 days. You can go down the hall, sign the bond over. It's in your name, and we're done. I wish you well.
Thank you, Your Honor.
Good luck. Thanks, counsel. Have a great day.
You too, Judge. Thank you.
Thank you.
Oh, yes, I think.
Please.
Somebody